matters of to be gone into in generality, and it's always been developed. Free speech has always been developed. Free speech has always been developed on case to case basis. So, what your lordships we had suggested for your consideration, both the learned SG was there, both the learned SG and I had suggested that this should be developed case by case basis. Now, here five questions, general questions have been referred to the Constitution. Now, if your lordships, if they want to, if the petitioner is not here, but if they want to argue, they can argue the same matter before a regular bench, your lordship.
Shall I point out one? Shall I point
Only a minute,
appearing for the
Mr.
petition?
Only a minute, only a minute. Let us just complete the first part. Is a permanent. Lord, the learned AG was not there on the last occasion when I gave this suggestion.
Yes.
Lord, here, one individual made one statement, which was a horrible statement. Nobody questions that. Now, my lord, the questions which are referred for consideration, as the learned amicus also very rightly points out, are more of an academic nature. Whether one of the question, by way of an example, whether an individual is amenable to a writ jurisdiction on the ground of violation of Article 21 of the Constitution. So that can be gone into on a case to case. It may perhaps, my lord, not require your lordship's investing time, my lord, in this combination. It can go before the, my lord, regular bench for two reasons. A, in the meanwhile, after the reference, there are two judgments, my lord. One in Tehsin Punawala and another is, my lord, Amish Devgan, where, my lord, the Honorable Supreme Court has laid down detailed guidelines and issued detailed directions as to what is to be done when such speeches are made, where hate speech is made or anything, my lord, which is abhorrent to the society. So those that law is already occupying the field. So, my lord, we were just wondering. We are on, my lord, ad item on that, subject to your lordship's approval. The learned attorney, my lord, would further address that it may not require your lordship's investing time, my lord, considering, my lord, the issues have been now occupying the field and this being essentially academic without factual foundation. And it would be very, my lord, not only difficult, but at times counterproductive if your lordships lays down one way or the other. There might be, my lord, flurry of petitions against individuals misinterpreting the judgment, interpreting the judgment, etc., which was never intention of anybody.
No. Are you saying, Mr. Solicitor, in view of the two judgments, for the present, it is unnecessary to go into all those?
That's
this is what you are suggesting.
In fact,
Yes, my lord.
I applied mine to all the questions. The lordships will notice that a very narrow context of a speech which may not be acceptable at all, non-condonable.
No,
To open up that context for a larger number of other abstract questions become problematic for the court to answer them in the abstract. So each one of the questions are very framed in an abstract way. So right from after Kasturilal and then Radul Shah, has been in case to case basis. The violation of fundamental. What's that compensation? In my opinion, ever since the law commission thought about a tort law and 67 bill was introduced, it did not become a law. It can be a matter preeminently fit for a positive law and which can take note of various limitations, immunities, liabilities. For the court to go into and leave them in the abstract could be definitely problematic. And therefore, these narrow contexts can be dealt with before a division bench in its own ways. So I would very humbly advise the court that these questions framed being too abstract, and the court may not be advised to answer them again in the abstract proposition. For instance, question number 1 itself, to say that one fundamental right can be pitted against another fundamental right, is a well-known proposition in constitutional law that there is no hostility between two sets of fundamental rights. They're only balancing of fundamental rights. So this balancing has now been propounded in a different way. I think the court may not like to answer them in the way have been propounded by the court. And that's my very humble understanding.
Shall I make a humble submission for the petitioner, Milo? Shall I make a humble submission for the petitioners? Shall I make a humble submission? Before your lordship deciding on this, Milo, shall I make a very short
do you say,
submission
Mr.?
on behalf
Yes,
of
tell
the
us.
petitioners?
Tell us.
Yes. But I wanted to make a submission
Ah.
regarding this reference. With respect to what the learned Solicitor General has stated, Milo, I may point out one aspect. Both this Poonawala judgment and the Amish Devgan judgment were delivered exclusively, Lord, in the context of hate speech in general, in abstract. Whereas the reason for referring this particular matter, both, is, Lord, we are rather concerned with hate speech or even disparaging speech by public functionaries. This element of public functionaries is an element which is lacking in other cases, which was never decided with focus on that aspect by any bench of this honorable court. Secondly, your lordship may kindly see both this Amish Devgan judge are questions of every constitution bench matter to some extent academic. Even Bombay judgment in 1994, but the assemblies were resolved far long back, elections were carried out long back. Then still it was decided, which evolved the federalism doctrine as well as the doctrine with respect to secularism. That was in 1994, long after the elections were over. In this case, Lord may please see one speciality. We were suggesting the way out. What a public functionary, a minister, or a member of parliament, or a member of legislative assembly makes a speech, a speech which is not in the strict sense constitutional. To what extent the court can interfere? But last time when it came up, your ladyship was asking, Justice Nagaratnam was asking a pertinent question. How long the court can go into that because of 19 limitations? We agree that. We absolutely agree with that proposition. But then, how to balance? Does it mean that a minister or a member of parliament can go on with this kind of disparaging remarks, hate speech, hateful speech? And is it constitutional or is it in tune with the constitutional morality? Whether there are constitutional limitations on their speech? But we suggested two things. One, Milo, taking a clue from other jurisdictions, especially from Australia and UK, we suggested a voluntary code of conduct for ministers and public functionaries, number one. Number two, we suggested constitution of a special ombudsman type of device, institution to tackle this.
How,
And till then,
how can we frame a code of conduct for public functionaries?
the court cannot.
Would
That's
we not be
exactly what I am
transgressing our
saying.
powers under
Correct.
Constitution?
Absolutely. What we are,
Encroaching upon the legislative and executive wings.
the lordships are right. Lord, we were suggesting a voluntary code of conduct to be formulated by the legislature. This is in that way only. But the question ultimately is, Lord, we have suggested or indicated, Lord, in the relevant paragraphs, in paragraph 50, 51, and 52 of the notes which I am placing before the lordship, Lord, about 20 instances where member of parliament, even the prime minister is joked, even the laborers, everybody is rather mocked at by members of parliament, ministers in the state, even president of India is mocked at by a minister in a state. Now, this is the situation. This I have given a data after 2014. There has been a 450% increase in the number of hate speech, out of which the major portion is shared by public functionaries, ministers and members of parliament. This was never decided.
Kaleshwaran, is there no provision in the IPC, to prosecute in such events,
In fact, your lordships are right. In one judgment, a distinction was drawn between hate speech amounting to offences in the relevant code, including IPC, and there may be hate speech which may not be per se a penal offence, but nevertheless will have an impact on the right to dignity of others. Whether that can be done, even when it is not an offence, whether that kind of speech can be done by a public functionary, a minister, or a member of parliament or legislative assembly is the question. Sometimes your lordships are right. That distinction was drawn in Amit Devagan. Amit Devagan said, two types. Poonawalla also indicated that. Kodungalur Film Society judgment also indicated that. Sometimes it may amount to an offence. The question, what we are proposing is an institution, an ombudsman-like institution, which may reprimand, which may oversee, which may help maintaining a constitutional culture in the public conduct of public functionaries. This is a novel thing which has been placed, and this is the big root cause for reference, which cannot be undone without by simply saying that it is an academic matter.
Room, my learned friend is appearing, but these are all
appearing in 501 petition.
We have intellectual curiosity to address all these matters, but the matters of positive law. A parliament may address all these concerns and may find out what kind of limitations, normative considerations may be involved to ask the court to get. That's why I said to abstract a proposition to say for a statement made by a minister there is vicarious liability for the government. So in different circumstances, so a roadmap has been drawn by the court over a period of time, and they will be applied as and when a situation arises. But to pick up a statement made by a minister as a liability principle for state, it's going to be a unmanageable proposition. Therefore, it will be in the fitness of thing that the parliament may address it. Government will look into it. So even in US, there's a section 1983 provision which came back in the context of the racial issues and the immunities and privileges matters. So now today, US Supreme Court is rethinking on whether the concerns on immunities and privileges have been spread very overtly. So then at a later point in time, the court may have to sit back and say, have I drawn it in a abstract way that it becomes unmanageable even for the court to lay down in from principles or to apply it.
See, as far as public functionaries are concerned, irrespective of what 19.2 may say, is there no constitutional culture in our country where there is an inherent limitation or a restriction which is imposed by persons holding responsible posts. It is inherent. There's no need for this court to give a code of conduct on that. Any person holding a public office or is a public servant, there is an unwritten rule and it is part of constitutional culture that we impose a self-restriction when we hold offices of responsibility and not blabber things which are, very disparaging or insulting to our other countrymen. There is something like a constitutional, restriction or limitation inherent in such persons. So this must be inculcated in our political society and our civic life.
Right, exactly. We agree that. That is why we never said that this court will have to formulate a guideline. We only said there is a requirement to indicate the need for a voluntary code of conduct. But it is high time, Lords may please to see that we have indicated some 25 instances in pages 41 to 40, pages 41 onwards, pages 41 to 45. 25 instances. They are all ministers or members of parliament. When they do that,
When the judges are comparing, is it not appropriate that there is some silence from the other side?
Free speech is restricted.
the Lordship,
Use of free speech, man.
free speech,
Abuse of free speech.
free speech and hate speech are taken together. Often hate free speech is taken as a hate speech.
Yes,
That
please
is
give
the
us one.
unfortunate part of it. If
Please
you're
give us one or two. Please give us 1 or 2 minutes.
yes, I'm sorry.
If you permit, we'll continue.
Extremely sorry about it.
Attorney General.
We'll ask you, the question is included.
Attorney. What have you got to say? What you are suggesting is it is for the parliament because there is already a provision in the IPC.
Yes.
If they want to add something more to it, maybe to bring within its fold, it is for the parliament to.
That's
This
right.
is what you are suggesting.
That's right. In fact, of course, assisting the court is not a problem. But to assist for what purposes and ends, ultimately we spend a couple of days' time and we reach the same conclusion. I prepared a small note. You'll also just look into it, and then, if possible, on the basis of this note, the matter can be closed.
Person. And also,
I didn't, and this note does not go into in extenso all those issues, but only for the purpose of answering these issues.
and also give us those two judgments also, we will have it.
Yeah, that's right. There are two, these are two judgments. One is 2018, 9 SCC
Yes,
501.
yes.
The next one is 2021, 1 SCC 1. And in both matters, there are detailed guidelines and then principles stated, which will be sufficient enough to deal with this.
Mr. Kaleshwaran, do you have this?
I couldn't
Yes, I
share
have.
it.
Copy of this?
No, I couldn't share it with him. Let me.
I
but
don't
didn't
have
know-
that
I didn't
judgment,
know it was
but
appearing.
I have prepared a written submission which contains not indication with respect to both these judgments, where the relevant paragraphs have even been quoted. And after that, I said that there are instances which may not attract the penal provisions made by the parliament. Therefore, there is a dearth. There is a vacuum. That is the condition. You Lord may permit me also. My colleague is there, Ms. Radha Lakshmi is there. She will, I am sorry that I am not physically before your lordship on account of certain medical constraints. My learned friend will hand over that written submission to your lordship, which is a 57-page note, which takes in both this Poonawalla judgment as well as Amish Devgan judgment, and which says, in fact, that this is not enough to tackle this issue. The problem is precisely this. In many of the instances, 90% of the cases, but the respondent is rather the parliamentarians. The lawmakers make this. The ministers make this. Therefore, should we again leave it to the legislature, or whether the existing law, at least with respect to Human Rights Commission, your lordships are aware, I have suggested invocation of Section 2 of the Human Rights Act, invocation of Section 12 of the Human Rights Act, but the Human Rights Commissions are not so far activated in this regard. Your Lordship may kindly
Right.
applicate to these.
What we suggest is, Mr. Kaleshwaran, let us hear Mr. Attorney General, and thereafter you can make your submission. Let us see how things.
One concern, when you try to place the judgments for the purpose of inviting the attention of the court, it is not that there will always be a residue which is left out in some judgment or the other. You don't pick up that residue and say, now I lay some further proposition again. My only concern is it will be in the abstract again. To ask the parliament or a government to say, all right, there's a code of conduct required. All this, the very fact that the court has framed these questions and the government's attention was drawn to it, and the fact has been in the public domain, itself is a sufficient attention paid by the government. For the court to go into it and say, we want you to have a particular institution, that must be a matter of parliamentary concern. Yes. Your Lordship will keep the issues framed alongside my note so that these are the issues framed by the court on 24th of October 2019. That's his one.
Yes. This is dated 24/10/2019, right?
That's right. So the first question are the grounds specified in Article 19(2) in relation to which reasonable restrictions on the right to free speech can be imposed by law exhaustive, or can restrictions on the right to free speech be imposed on grounds not found in Article 19(2) by invoking other fundamental rights? My answer to that is, as a matter of constitutional principle, any addition, alteration, or change in the norms or a criteria for imposition of restriction on any fundamental right has to come through a legislative process. It can be stated that the restrictions that have been enumerated, for instance, in Article 19(2) to 19(6), have to be taken to be exhaustive. Given the position that such restrictions have to be taken to be exhaustive, the court may not invoke any other fundamental right, namely Article 21, for imposition of restrictions not found in Article 19(2). It's also a principle of constitutional law that there can be no conflict or collision between different fundamental rights or freedoms. As such, one fundamental right cannot be pitted against another fundamental right. Balancing fundamental rights, either to avoid overlapping or to ensure mutual enjoyment, is different from treating one right as a restriction or another right. Then, question number 2, can a fundamental right in Article 19 or 21 of the Constitution of India be claimed other than against the state or its instrumentalities? Answer. The Constitution itself sets out a scheme of claims of fundamental rights against the state or instrumentalities, and is also enacted in respect of breaches or violations of fundamental rights by persons other than state or its instrumentalities. Any proposition to add or insert subjects or matters in respect of which claims can be made against persons other than the state would amount to constitutional change. Such changes may not be suggested or propounded as matters of interpretation. The concept of state action is propounded and applied in US constitutional law, and the enactment of so and so are to be seen in the context of peculiar state of affairs dealing with governmental and official immunities from legal proceedings. In view of specific provisions of the Indian Constitution, the Articles 15(2), 17, 23, and 24, there may not be strict need to take recourse to law obtaining in the USA. However, the concerns that have also been voiced in regard to unqualified liability principle also deserve to be kept in view. Consequently, claims against persons other than state, either through enacted law or otherwise, must be confined to constitutionally enacted subjects or matters. It is submitted that enlargement of such constitutional principles will also have the consequence of opening a floodgate of constitutional litigation. The principle of where there is a right, there must be a remedy, must also be a matter of positive law. Then issue number 3, whether the state is under a duty to affirmatively...
Mr. Attorney General,
I'm sorry.
there may be no right against the state when a particular individual makes a statement. But on account of that public functionary making a statement, if a section of the population or an individual is affected, there is always a civil remedy available. So it cannot be said that there is no remedy. With regard to answer to question number 2,
No.
there is always a remedy available.
For instance, we have the SC/SC legislation.
Apart
Right.
from
Then the bonded labor legislation. Legislations take care of all these private actors' violations.
under defamation, a civil tort. So it is not that there is no remedy at all. There is a civil remedy also may be availed by a person who claims that he or she I am on civil remedy.
When
No.
the
It's always available. It is not against, it may not be against the state, but it may be against the particular person making the statement.
No, for instance, we have a principle of defamation.
Yes.
That's right. Therefore, Therefore, there are disparate principles available in various legislations here and there. Maybe there is a need for a codification. That's a different issue. But today the court is not called upon to answer the question of a codification of all these disparate principles and put them in one place. And I don't think whether that exercise would also be worthwhile doing in the context of this case.
But under the existing legal regime, a remedy could always be thought of by an individual if he or she is hurt
Right.
by a particular speech.
That's right.
Attorney, in any case, can we do it? It's exclusively within the domain of the parliament. That's what primarily I feel.
My reflection were we not setting some very obvious things while framing this question? That's something very obvious.
It can go to the court individually.
Concerned about again question number 4. Can a statement made by a minister traceable to any affairs of a state or for protecting the government be attributed vicariously to government itself? Especially in view of the principle of collective responsibility. Too many ideas have been jumbled up here. Now, the collective responsibility is an entirely different governmental concept.
Attorney, it is like saying the statement made by a judge is attributable to the court.
Exactly.
So I was worried with Mr. Kaleshwaram Raj said, public functionaries, whether it includes us also. And whether the speech would include irresponsible statements also.
Fortunately, my lord, there was no instance
There have
of
been
that
some
kind at
thoughts
all.
on institutional responsibility.
But it is meant to the learned attorney, not to you.
Let me have my answer to that. Issue number 4. Answer to issue number 4.
Going further, suppose if
Or 3.
some wrong judgment is given by one bench, can it be attributed to the entire Supreme Court?
Certainly not. Certainly not.
You have missed question
And
number
then-
3, Mr. Attorney, you have missed question number 3 you have missed.
No, that is what you are saying.
No, you answer question 4.
Question 4.
3.
Yes, answer to issue number 3. I'll read that and then come to issue number 4. There are sufficient constitutional and legal remedies available for a citizen whose liberty is threatened by any person. Beyond the constitutional and legal remedy and protection available, there may not be any other additional duty to affirmatively protect under Article 20, the right of 21 citizen. Case of infringement of fundamental rights are taken care of under Articles 32 and 226. It will always be a matter of fact whether there is an infringement at all. Then answer to question number 4. Conduct a public servant like a minister if it is traceable to discharge of a public duty or duties of office or subject to scrutiny of the law. Sanction for prosecution can be granted if misconduct is committed under color of office. Such misconduct, including statements that may be made by a minister, cannot be linked to the principles of collective responsibility. The concept of vicarious liability is incapable of being applied to such situations, and no government can ever be vicariously liable for malfeasance or misconduct of minister not traceable to statutory duty or statutory violation for the purpose of legal remedies. Ministerial misdemeanors, which have nothing to do with discharge of public duty and not traceable to the affairs of the state, will have to be treated as acts of individual violation in individual wrongs. To extend in the abstract the liability of the state such situations or instances without necessary limitations can be problematic. That's where I'm voicing my concern. And we can't foresee what kind of limitation is necessary at this point of time. And that's why even in the end of compensation, from Rudul Shah onwards, the pendulum has swung from one quantum to another quantum. So therefore, it may be a need for a legislative intervention, but that does not mean that the institutional proposition being proposed will have to be seized in this case.
Yes.
In view of my answer to the other questions, I don't think question number 5 even need to be gone into. Nilabadi Bera has said about constitutional thought. Is already there a proposition of law. I don't think that another chapter to be added to that.
So it covers all your submissions. If you want to point out something from Poonawalla.
I don't think I need to travel any further on this.
Unless you want to point out something from Poonawalla and you want specifically to point out something from Poonawalla.
No, I don't think because then that will take the court into a long journey again into all these questions.
What you are saying is it requires a legislative interference, that's all. This is the sum and substance.
That's right. Because the issues are now before the court will look into them and say yes, it may be preeminently a fit subject for a codification. Look into it.
There is already a legislation in IPC. If any addition is required, it is for the legislature. This is what
That's
you are
fine.
suggesting.
Whether it's an addition to IPC or a need for a complete codification, etc., all that will be matters of parliamentary debate. But I see even across the globe, these issues have come before different apex courts. But for the courts to lay down final binding principles of liability on government for individual misconduct will be a very serious issue.
Question is whether there is any.
When the parliament applies its mind, it can say yes, there are the following limitations, and there is a debate, and then it will be tested in the court. But before that, we want.
See, the reason why there is no legislation all this while, is there has always been a self-imposed
I'm sorry.
restriction.
I'm sorry.
The Attorney General. The reason why there has been no legislation all this while is because there has always been an inherent, a self-imposed restrictions by persons holding responsible positions in public life. Now, the impression being given is that those kind of restrictions are being slowly relaxed. As a result, persons are speaking in such a way which is offending other persons, and nobody is checking it. That seems to be the thrust of this whole.
Exactly. I mean,
rather than going into the nitty-gritty of Article 19(1)(a), 19(2), etc.
The concern is well taken.
The concern is this. See, nobody seems to be checking them. And anybody can get away with saying something which is disparaging against somebody else. Especially persons holding high offices, public functionaries, public servants, what you may say. This is the object of this case. And going into whether
the reason why these cases come before court, all that the concerns are well taken. I'm not even disputing for a minute. As the highest officer of the state, I don't think that these are to be simply wished away. No. But then how do we really address those questions? That's the most important aspect of the matter. Do we address these questions through a debate in the court, and then how far we can foresee all those limitations and the inherent intrinsic difficulties which may arise when the court is called upon later to apply its own law. So therefore, in my understanding, it's better that there is a parliamentary debate on this question and Parliament can look into it. And maybe there is a need for a law. I'm not even,
Yes.
maybe there's a need for a law. But
There is
then
a need for a law.
we look at the larger percentage of responsible persons in public offices who know what to speak and what not to speak. We are only picking up those people who have probably aberrations which happen.
Explain.
So the aberrations must be taken care of. That's about all. It can be different. For instance, the remedies which are ordinarily available to an ordinary against an ordinary citizen and a public functionary, if there is a excessive protection to public functionary, one can understand. But there is no such excessive protection. We have a section 197 CRPC also very strictly read. So it must be the discharge of public duties. If not, then you face the music of the law. That's why even in Tehsil Pulawala in para 40.1,
Notes covers everything.
very well.
Yes, Lord. I just wanted to make 2-3 submissions only, based on my written submission, which Lord is by this time placed before your Lordship.
Yes, we have.
Lord, 3 broad submission which I will make. But it is not as if, Lord, I am opposing the central stand as such. But we also do not say for a moment that this court will be imposing additional restrictions on free speech, even the free speech of the public functionaries. We don't say that. We only say that when they are public functionaries, well, as your ladyship was indicating, there is an added responsibility in them to maintain the constitutional culture in their public conduct in public domain. This melody is to be addressed. That is number one. We don't say that additional judicial restrictions can be imposed on free speech, even of public functionaries. We don't say that. Article 19.2 or 19.1 as it stands, but unlike 25 or other articles, does not permit it even. We concede that. Secondly, we say that there, even if your free speech is as such applicable to public functionaries, subject to other constitutional limitations, nevertheless, but hate speech has to be distinguished from free speech. This is my second broad argument. Hate speech, when made by a divisive speech, when made by a minister of the state or center, but even during communal rights, certain times it may not be amounting to an offense, but some public check will have to be there, even when it does not amount to an offense. This is my second broad proposition. I have given certain instances and suggested but to 2 methods predominantly. That is the third submission. The 2 methods are, but it is unless and until the legislature or the government is motivated to do that, but they may not even think of promulgating a voluntary code of conduct. So far, it has not happened, and this remains unchecked for almost a decade. For the last decade, any minister, any MP, any MLA can say anything, irrespective of the consequences. Is the situation. This is something unprecedented. I have given the data also in my written submission. And lastly, what I have suggested, even when it does not amount to an offense, even when a poor victim, a lady or a laborer or a minority community person may not be inclined or facilitated to set the law in motion, but there has to be a mechanism in a country like India where I have suggested ombudsman with his history.
No. Can we do that, or is it for the parliament to set up a mechanism? Or
your lordships are right, my lord. I agree that your lordship may have to clarify the gravity of the situation and suggest it. Very many things, my lord, and even now, your lordship may please to see the human rights commissions are rather deactivated. That is a prime concern. State human rights commissions are there.
Yes.
Because state human rights commissions are there, the National Human Rights Commission is there. Even at the time till, I am not even saying that a judicial legislation is required. I don't say that. I am only saying that unless and until, hopefully let us have an optimism that the Parliament will promulgate a law in future, if at all. Till then, I am not that optimistic, at any rate, for the sake of argument, I am saying. Till then, we're invoking Section 2D of the Human Rights Act, the Protection of Human Rights Act. But there are State Human Rights Commission and National Human Rights Commission. The definition of human rights involved a right to dignity. Human rights as defined under Section 2D will necessarily include a right to maintain dignity against hate speech as well. That is how one can read Section 21D of the Protection of Human Rights Act 1993. What human right means the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. But this is how human rights are defined under the Act. And the commissions under Section 12 are empowered to take cognizance either on complaint or even suo motu, which never happens at least in one among the 25 instances which we have indicated in the written submission. Not even single instance is there where the Human Rights Commission has acted. But this is therefore an issue which may require some deliberation. Otherwise, it will again, if it is left to the parliament or lawmakers, when this is the situation when lawmakers themselves do it sometimes, unfortunately, but can this court be taken as absolutely helpless in this regard is the question. I am only seeking a middle path. I am not saying there will have to be some kind of reconciliation. But Nelson Mandela famously said, for to be free is not merely to cast off one's chains, but to live in a way that respects and enhances the freedom of others. I think and I submit that this would apply to the public functionaries as well. I am not seeking any curtailment. We all have the 19.2 is broad enough already, as your ladyship was indicating the other day. But we cannot impose further restrictions. The Lordship will not be doing that also. I perfectly understand that. I agree. I respectfully agree with that view. I support that view. But I am only saying, but something which is not penal, some institution which is empowered to reprimand, to give a close watch on it, but that is required. That is a constitutional requirement in these tough times. If your lordships are agreeing to deliberate on this, but I can supplement the further materials. How? But there can be voluntary code of conduct, not something which is, your lordship can always suggest that. Your lordship may not be imposing that. I can give certain good models from other jurisdictions. Secondly, but a special ombudsman for this, which may not be punishing persons for what they talk, but which can always reprimand the public functionaries, which will put certain fine guardrails against the public functionaries. That is an imperative, but in our constitutional climate, as it now stands, this is my submission. I placed my written submission before you.
All right. Yes, Amicus wants to say something.
Yes, Your Lordship. My submission is that first, of course, I indicated, Lordships, these issues can be gone into in a regular bench because most of these issues which have been raised have already been decided by this court. Now, the concern raised by Justice Nagaratna. Now, we have a public law remedy for violation of fundamental right, and that is constitutional tort laid down in Neelabati Bahera. So let us take an example. If by a statement made by a minister in his official capacity, it violates the fundamental right of the citizen, this court, under the law laid down by Neelabati Bahera, common cause, will act against the minister in its public law remedy.
But the contention appears to be, we don't have sufficient statutory provisions as of now.
Yes, Your Lordship.
What do you say for that?
Your Lordships, as far as the ministers are concerned, there is a code of conduct. But your lordships have also held that code of conduct is not enforceable in the court of law. It is for guidance. It is in Jaya Lalita, that's what your lordships have held. So at the most, my submission is that we are talking about free speech of a minister. Now, if the question of collective responsibility doesn't arise, if the minister in his official capacity, let's suppose he tries to make a statement which interferes with investigation. Now, that's clear violation of fundamental right, and that would be covered by constitutional tort. In fact, your lordships, in the case of state of Maharashtra, where a chief minister had actually interfered with investigation, had made the chief minister party before this honorable court and imposed costs on the state because the minister is the functionary of the state. So that is how your lordships have dealt with individual situations. But when the court is asked to lay down general guidelines, now, lordships, the problem there is one stray observation of the court can affect many of the rights under 19(1). That is my apprehension. Now, it is not my case that the petitioner does not have a remedy. If the petitioner proves that his statement, the statement of the minister, has violated his fundamental right, then the law is already settled in Neelabati Behera. And in fact, in common cause, it was argued that this court can invoke constitutional tort only in Article 21 cases, and that has been specifically negatived by the court. So there are other fundamental, and as far as actors, non-state actors are concerned, lordships, that issue doesn't arise here because we are talking about the statement of a minister.
The repetition. And I was given the liberty to get myself included in the repetition. So far as the first question is concerned, it has been referred for consideration. I have a submission to make. The Lord was asking, can we at all, if there are remedies available, can we at all consider the question over and above 92? That is one of the questions which is included in question number 1. And the notes, the suggestive questions which has also been submitted by the amicus. So if your lordships come to 19(1)(a), there can be two ways of looking at the speech being made by the public official. One is, my lord, he makes his speech or the statement or expression, whatever it is, in his capacity as the public official, for which he will never have the protection under 19(1)(a). So far as he is making a speech, even after being a public official, he can make a speech as a citizen alone. He will get the protection under 19(1)(a) only if he makes a speech or expression as the citizen. Therefore, my lord, what happens is this first question, so far as please come to 19(1)(a). If your lordship is taking 19(1)(a).
My learned friend is appearing for the intervener.
Yes.
Let him assist, let him assist.
(19)(1) begins with this, my lord. This is a positive right given to all citizens. All citizens shall have the right to freedom of speech and expression. Now, any person making a speech will get this, but it will be eclipsed. Why not? The restriction is contained under 19(2). Whatever is reasonable will be contained under 19(2). But the moment he steps into the shoes of the public official and makes a statement, 19(1)(a) is gone away.
So he ceases to be a citizen of India.
No.
He happens to be the citizen of India. He will not take himself away from the citizen of India. But then he will not get the privilege of 19(1).
Why?
That is what?
Why?
Well, my submission.
Nobody says that.
This is akin to.
This will be rewriting the constitution.
May just make the submission good, my lord. Please hear me out of this question. I am a little sticky pitch. I understand. This is the best question we should come. He still happens to be citizen.
So your contention is to be accepted.
Yes.
19(1)(a)
Yes.
would exclude the public officials from the protection.
Therefore,
So they will not be a citizen. They will not be citizens for the meaning of 19(1)(a).
provided he steps in the shoes of the public official. Why I say, my lord, the same rights are available under First Amendment to the US Constitution. The First Amendment was interpreted to say that the moment you exercise the right as a public official, you will not get the protection under the First Amendment. 19(1)(a) is similar. Therefore, my lord, envisage a situation. Minister is acting as in the cabinet. he makes a statement, comes out, makes a statement or gives a speech as a minister. Now you will take it as the minister's speech, he will not get the protection under any one. He is also having the immunity. Say, for example, Article 104. So whatever happens in the Legislative Assembly, he gets a protection, he gets an immunity. This court has held that those which are available under 104 is not guided by 1918. The restrictions cannot be 19.2 as well. The restrictions are those which are contained under the rules of the Legislative Assembly. Therefore, my lord, the moment a person, whoever it is, if he is holding a high post, even for my lord, at times there are wavered situations in which the judges come to the court and has argued some cases as well. He will not get the protection of a judge. He will not get the protection of a citizen under 1918. He cannot be taken to be one of making a speech under 1918. You will not get the protection at all because you have put yourself in the shoes of the public official. That is why, my lord, my submission would be, therefore, this question becomes important and that has been submitted by this has never been considered at all. Because once you step into the shoes of the public official, are you entitled for the protection under 1918? It needs to be decided. That has been referred to in the question. First question concerns that as well. Therefore, the first question also says whether over and above what is contained under 19.2, the reasonable restrictions, can there be more restrictions? So far as a person who is a public official, my lord, though part 4A does not say, my submission to this is what brought from my lords as well as Justice Nagaratna as well. The constitutional principles are there and there are fundamental duties as well. Now, for a person who becomes a public official, rather than what is contained under 19.2, you will have to necessarily abide by Part 4A. Part 4A, 15.1A2, my lord may have a look at 51A 4. Sorry, E. Therefore, over and above 19.2 is the power of the state to enact a law. Now, he is even without a law, he is bound by this and also by the oath. Also by the oath, you will abide by the constitution and constitutional principle. Please come at 51E, capital E, A capital, 51 capital A E. To promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to promote practices directly to the dignity of woman. In my case, this is what has happened, but let us, notwithstanding what has been stated by the minister, my lord, 19.2 alone should not be the relevant factor for a person to be guided as to what his rights would be under 19.1. There are judgments, if your lordship is going to this question, my lord, there are judgments. Therefore, today, my lords may have to necessarily decide. And when there is clear, now we are not alone, my lord, concerned with the speech being made in an assembly. We are all the more concerned with the statements a person makes in the social media or in Twitter or Facebook, whatever it is. The public officials comes out, make the statement, the reach is huge up. The responsibility or rather the presumption is that he has access to the information and the information is being disseminated. Now, therefore, what happens is, unless otherwise there is a higher pedestal than 19.2, which is what is to be decided by lords, whether at all a public officer acting in his capacity as a public officer has the rights contained under 19.1. It is only, I can, my lord, it can necessarily, I will be, my lord, in the event of, my lord, disseminating a public opinion, generating a public opinion, act as a citizen, make this a speech, uses the technology, uses the social media or whatever is there to disseminate information or to exercise my right to speak. But the moment I use it as the public office, there may be, my lord, the misconduct taken as against me. But that alone would not be sufficient because you are also bound by the constitution and the principles contained in the constitution which is being violated. What happens thereafter is that he gets
Understood your submission.
Yes, what I do is.
You
All right,
give
all right.
your written notes. You
That
consider
would,
it.
that would be better, or that I'll restrain my speech.
All right.
You would be entitled.
That's all? Yes, solicitor, you want to say something?
Lord, I would not waste your lordship's time, my lord. I'll say, my lord, so on the same lines, I'll give my, my lord, written submissions, my lord.
Yes,
Why-
attorney, you want, yes.
Only one last word.
Yes.
For public servant, there are rules of conduct. If you breach the rules of conduct, then you face the consequences. So we are talking about whether the court will lay down this kind of rules of conduct in a very important dimension of free speech. And therefore, a higher pedestal than Article 19.2, which will be asking the court to introduce into 19.2 something which the parliament has not put in. It's fascinating to say a higher pedestal. Of course, the nation may need all kinds of limitations on conduct of public servants. But do we have, in the context of this particular case,
The first
The-
amendment itself was necessary because of certain.
that's right.
Shall I just point
I
out one
very
thing?
humbly advise that the court may not go into these questions and answer them beyond whatever is necessary for answering them as
Yes,
indicated.
Kaleshwaram, yes.
Yeah, just one submission, my lord. I am also agreeing, my lord, broadly that, my lord, the questions are slightly problematic. My lord, I do concede that. Whether these questions should be retained as such and answered as such, my lord, is something which your lordship may decide. My lord, I don't say that the questions are very novel, but I nevertheless maintain that the issue is novel. Therefore, what I would request, Lord, I am also giving a compilation along with my written statement, which is a large one, a big one. Your Lordship may consider these suggestions, in the context of public functionaries in particular. I have given the suggestions, I have given the entire
All right,
material
all
as
right.
my compilation.
We will consider. Yes,
Grateful.
Amicus, you want to say, you want to add?
Lordships, I don't want to waste your lordship. I have already given my written note, written submissions.
All right, thank you very much, reserved.
Grateful.
Right.
Grateful.
There's also a compilation which I can hand over to the Technology.
Yes.
What volume?
Yes. Okay, Ram.
Yes, Lord. Lord, here the question is,
Just 1 second.
May I state the question?
only a minute, I'll say, different is for the petitioner, but I have to say something at the outset, my lord, so that if can be considered at the outset.
Yes.
Lord, the question is this. Question is interpretation of Article 105. Article 105, sub-article 2, which provides for an immunity to the members of parliament, and my lord, corresponding article is there for members of the legislative assembly, which is called, my lord, privilege or immunity from prosecution. My lord, that arises in terms of, my lord, two instances: A, voting; B, something which is spoken inside the house of the parliament. Your lordships are aware, in our parliamentary democracy, the whatever happens within the house is supreme. Outsiders are not permitted to interfere. Lord, the question, my lord, I am not going into the facts of the case, but only for the purpose of what is relevant for me to point out at the outset. This is a case where the petitioner is alleged to have taken money for the purpose of voting in a particular manner inside the house. she did not vote as per the the desired wish of the person paying the money. That's the allegation. The question arose whether she is protected by the immunity or not. The court answered the question in a particular way, which right now your lordships may not go into. The CBI raised the contention that she is not protected. They raised the contention that she is protected, etc. When the matter was being argued before the regular bench, when I say regular bench, it means other than the constitutional bench, the judgment in case of P.V. Narasimha Rao was cited.
Yes.
And cited by them. Not just P.V. Narasimha Rao judgment, which is a constitution bench judgment, the similar question arose. What is the extent of immunity of members of parliament and legislative assembly? Here it was a member of parliament question. Lord, out of 5 learned judges, there were 2 questions before the constitution bench. A, whether the members of parliament and members of legislative assembly are public servants or not. And second, whether they are immune so far as the question of voting and question of their speaking something within the house is concerned. Lord, out of 5 learned judges, 3 learned judges, my lord, namely Justice S.C. Agarwal and Justice Anand, who were in minority, held that though they are not protected. Third learned judge, Justice G.N. Ray, my lord, differed and said that no, they are protected, though he concurred on the question of public servant, with which we are not concerned here in the present case. And 2 learned judges, my lord, Justice Bharucha and Justice Rajendra Babu, gave a detailed judgment saying that no, the protection still continues. Even in case of a criminal offense, the protection continues, and they have given reasons, they have not examined the case law, etc. So now this judgment is a constitution bench judgment where 3 is majority and 2 is in minority. Now your lordships may, my lord, kindly see the reference order.
Milords, that I think I should be permitted to place.
All right, we will hear you.
No, no, as the petitioner, Milords, I think I should, as an officer of the court, I'm equally bound, Milords, as the petitioner.
I'm saying something,
Raja Ramachandran, we
I'm
will
not
hear you,
saying
we will
something
hear you.
against you.
No, no, no.
I'm not saying something against
We
you.
will hear you. We will.
It's a question of law, therefore I'm nothing against you. I didn't mention the allegations also in detail. Because this is not the forum where we go into the facts. These are all broad propositions. Lord, kindly come to the order of reference, my lord, at para 4. The precise question was dealt with by a 5-judge bench of this court in P.V. Narasimha Rao versus State, while 2 judges on the bench took the view that protection under Article 1052 and 194 to 194 is for the Assembly of the Constitution of India, and the immunity granted cannot extend to the cases where bribery was for making a speech or vote in a particular manner in the House is alleged. The majority view, while acutely conscious of the seriousness of the offence, felt that the wrongful act of the sense of indignation of the bench should not lead to a narrow construction of the constitutional provisions, which may have the effect of impairing the guarantee to effective parliamentary participation and debate, something which my learned friend would be arguing. And I'm in principle, as a constitutional proposition, supporting him. Therefore, I'm saying, I'm not arguing anything against him. Having considered the matter, we are of the view that having regard to the wide ramification of the question that has arisen, the doubts raised and the issue being matter of substantial public importance, we should be requesting for a reference of the matter to a larger bench, as may be considered appropriate, to hear and decide the issue arising. We order accordingly, and the matter was placed before my Lord the Chief Justice on administrative side. Now the question is, it is P.V. Narasimha Rao judgment which is placed for your Lordship's consideration.
Mr. Tushar Mehta, therefore, supposing if we accept the majority view of in P.V. Narasimha Rao, probably this matter has to be closed.
That's right.
Supposing if you don't agree, it may have to go to a larger bench.
Exactly, that's all I am saying at the outset. That before we invest your Lordship's time further, if your Lordships will not agree that the majority view is correct, which according to me is correct, On the facts, my lord, we will argue before the regular bench, my lord, whether protection is there, not there.
That is on facts.
That is on facts. But on the proposition, my lord, the view expressed by my lord Justice Bharucha and concurred by two honorable judges is so convincing that it would be difficult, my lord, for any one of us to argue that this protection can be diluted because some facts are so.
Mr. Ramchandran will have to cross that hurdle.
Pardon? No, my lord, he is also saying the same thing. But
I haven't said anything.
Lord, for the purpose of, my lord, we are before the
reference
Constitution
that he
bench, we don't use such, my lord, childish humor. My lord. This is his case. My lord. This is his case. Sir, this is his case.
It appears that he must have argued the correctness of PV Narasimha, and therefore the three judges bench found it necessary to refer it to a
No, my lord, he relied upon PV Narasimha. He relied upon PV Narasimha.
So that we will have to ask him whether if he concurs with PV Narasimha, then there is no question of this being answered.
Answer, my lord, then.
Only in the event he is in a position to convince us that the Constitution bench in PV Narasimha does not lay down a correct proposition.
Look, if he argues, then he loses. Therefore, he argued that this covers my case. His argument before the three-judge bench was that I am covered and fully protected by the judgment in PV Narasimha.
But who is opposing him then?
On merits, I am opposing him.
Not on merits, on this
On proposition, I don't think, my lord, anybody.
But the court has said, see in paragraph 5.
That was God's view. That was God's view.
Doubts arise.
Regarding
But yes, that's what I am going to submit, Bullets.
Just 1 second, Ramchandra, Raju, 1 second. Right or wrong? Tell us now.
First of all, Bullets, let me clarify.
Yes.
I was not intending to be frivolous at all when I said I have not said anything. When I said that, it was in the context of the doubt.
Nobody said that you are intending to be.
No, my learned friend said childish humor. To that extent.
Humor, it was on the lighter side, I said. Don't. This is serious.
What I said was in the context anticipating the doubt which Justice Gawai expressed a little later. It is this, who raised the doubt in that context. Now, kindly, therefore, see the prior order first of 2 learned judges sending it to 3 learned judges. That's a prior order. That is Bullets 23/9/2014.
Yes, we have.
Lordship, please. Pleadings are complete. Short order. Justice Nagaratna has got it. 23. All my other lordships have got it.
Page 6.
23/9/2014.
Page 7.
Pleadings are complete.
Pleadings are complete.
Since the
issue arises for consideration is substantial and of general public importance.
Next one.
Since
Page 6 or 7.
7, page 7.
Six and seven, yeah.
Since the issue arises for consideration, is substantial and of general public importance, we refer these matters to a larger bench of 3 honorable judges to be constituted by Honorable Chief Justice of India. Petitioner shall be free to press this application for ad interim stay for the larger bench. So as far as this is concerned, it's a mere reference to 3 learned judges because of the importance of the matter. No doubt expressed about Narasimha Rao. Then, my lords, we may come to the order which my learned friend, the Solicitor General, has already read out, but I want to read it from my point of view. Here, my lords, this is a detailed order, and then there's a court proceeding also. Leave granted. Para 2. The criminal prosecution launched against the appellant is sought to be nullified on a claim of immunity under Article 194(2) of the Constitution of India. The gravamen of the charge against the appellant is that he had accepted a bribe to vote in favor of a particular candidate in the Rajya Sabha election that was held sometime in 2012 in Jharkhand. The precise question was dealt with by a 5-judge bench of this court in P.V. Narasimha Rao, while 2 judges on the bench took the view that the protection under Article 105(2)/194(2), because these are pari materia provisions for the state legislature of the Constitution, and the immunity granted cannot extend to cases where bribery for making a speech or vote in a particular manner in the House is alleged. The majority view, while acutely conscious of the seriousness of the offence, felt that the wrongful act and the sense of indignation of the bench should not lead to a narrow construction of the constitutional provisions, which may have the effect of impairing the guarantee to effective parliamentary participation and debate. Now, my lords, this is crucial, para 5. Having considered the matter, we are of the view that having regard to the wide ramification of the question that has arisen, I pause here for a minute on wide ramification. Wide ramification was there at the stage of Narasimha Rao in 1998 also. At any time when the question comes up of MLAs or MPs being bribed, the ramifications are wide and public morality is involved. There's no doubt about that. But that is why 5 judges were constituted in 98 to decide this question because of the wide ramification. The doubts raised and the issue being a matter of substantial public importance. So public importance and wide ramifications go together. The doubts raised and the issue being a matter of substantial public importance, we should be requesting for a reference of the matter to a larger bench as may be considered appropriate to hear and decide the issue accordingly. We order accordingly. Now my respectful submission is this. Doubts raised. Where were the doubts raised? It was not the petitioner's case that Narasimha Rao is wrong. Our entire case on merits is that Narasimha Rao was wrongly applied against me by the learned single judge of the Jharkhand High Court who decided the matter. That very case of Narasimha Rao supports me in my claim of immunity.
No,
Therefore, I did not say...
What you are suggesting is the minority view has been applied insofar as you are concerned.
No,
Is
not
it
even
your-
a minority. I'll clarify that. Yes. The minority has not been applied.
Yes.
Now, let me use a colloquial expression. A betrayal vote. What the learned single judge of the High Court says is that instead of the promised vote, for which I am alleged to have taken the bribe,
Yes.
to vote for X.
So that means the breach of contract will not protect you from Narasimha Rao. So specific performance is permissible.
Lordship, please. Lordship, please.
Instead of vote, the contract is opposed to public policy.
Please.
Is it?
Lordship, please. Therefore, that contract being opposed to public policy, the allegation in fact is that I didn't honor that contract and I ultimately voted for my own party's candidate. So instead of X, I betrayed X and voted for Y. Now, Milords, the High Court.
Substantial justice is done.
Lordship, please, Milords, as far as politically.
No, actually it is a case of cash outside the house and the conscience inside the house.
Lordship, please. Lordship has put it with respect very aptly, Milords.
No, but therefore there was no Absence of conscience outside the house. And Lordship, please, Lords.
Or
Now
some other contract.
Now let's
Rescinding of first contract and novation of another contract by somebody else. On the lighter side.
now where
And we are not on facts.
Lordship, the High Court applies that very Narasimha Rao and equates this betrayal vote, which was not contemplated in the Narasimha Rao case because those facts were not there. In the Narasimha Rao case, there were only two fact situations. That is, people giving the promised vote about 10 or 11 minutes, and one, that is the late Mr. Ajit Singh, who did not vote.
Abstained.
Lordship. Abstained. Lordship.
He conspired, but
See, it may be Raju Ramachandran. Why do you say it is a betrayal? It may be a conscience vote. No?
Lordship,
What is wrong if you say that?
No, conscience vote, but after allegedly having taken, because for the purpose of this argument before the Constitution bench, we have to take the facts as alleged to be correct.
So going by the
Minutes
analogy
before-
of the High Court,
I'm sorry,
going by the analogy of the High Court, had you voted in favor of R.K. Agrawal, then you were entitled to win.
absolutely, absolutely. So that is the anomaly, which is what I am going to argue. The only question involved is the
regular.
application.
That's what.
That's right. That's right. That is the only question I will be arguing before the bench of either 3 or 2, before whom your lordships may send me back. The faulty reasoning of the High Court, which I will argue they are not here, is in equating the no vote of Ajit Singh by a process of deductive reasoning, which I submit is faulty, to say a betrayal vote is equal to no vote. Our submission is a vote is a vote, and the language of Article 194(2) is in respect of any vote. 194(2) does not talk of which way a vote goes. In respect of a vote, if there is any kind of allegation of any nature, it could be bribery, it could be anything else. Therefore, if I, as the petitioner, have not asked for reconsideration of Narasimha Rao, and I'm only pleading that the High Court has erred in wrongly applying Narasimha Rao against me when Narasimha Rao ought to be applied in my favor. There's no question of questioning the correctness of Narasimha Rao. In which case, if the first order of reference only talked of wide ramifications, and the second order of reference talks of public importance, wide ramifications, and the doubts expressed, who with respect has expressed those doubts? The doubts on paper are only the doubts of the two learned dissenting judges. Powerful reasoning, no doubt. But that is the only doubt on record which could have weighed in the minds of this 3-judge bench. It would have been a different matter if this 3-judge bench had on its own felt and recorded that paras so and so, so and so, so and so of the majority judgment of Narasimha Rao appear to us to be doubtful in the light of so and so, so and so, and we feel Narasimha Rao may require a fresh look. That would have been sufficient reason. If a seed of doubt is sown in the minds of the bench, either by a party or the bench of its own accord entertains a doubt and articulates the doubt, then it follows, minutes, that the process of reference must be carried further through, as per the judicial discipline, first to 5 judges, and then 5 judges feel, then 5 to 7. But in the absence of such a judicially expressed doubt, in my respectful submission, there is no need for reconsideration of Narasimha Rao.
But Mr. Raju, one question or one doubt, our doubt.
Lordship, please.
Now, the court has expressed doubt on the majority view, right? By 3 judge bench. 1 minute, one by one. Now, neither Tushar Mehta nor you dispute the correctness of the majority view.
Lordship, please.
Now, but the court has raised doubt. Somebody should assist us on the other side also. There is none here.
If you're not
question.
read this,
Only a minute.
or sir, just 1 second, let me just complete this. If your lordships as a brilliant opponent read this sentence, and since one of the learned judges on the bench is before this in this bench also, that this itself means the doubts expressed refers to the doubts of the 3-judge bench and not the doubts expressed in the minority in Narasimha Rao, then of course, Milords, the doubts expressed by the 3-judge bench must be adequately addressed.
One more reason, Mr. Ramachandran, actually, this is the case of payment of money. Suppose there is a case members of legislature.
If it is held captive, if the family members, if it is not protected,
Not basic.
that's
Basic.
not the fact,
Now, if
that
you
is not the fact situation.
you substantially damage.
Mr. Solicitor and Mr. Ramachandran, now in any case, the bench of 3 learned judges, we don't know what was in the mind.
Correct. Well, is referred.
And also, I want to add, I am also a party to that.
Yes. Lord, if my learned friend allows me, he has substantially diluted his case, my lord. Let me, my lord, further.
And if you allow us,
I'm so sorry. I'm so sorry.
the 3 judges bench has raised some doubts with regard to correctness of Narasimha. So we have to honor the,
Certain. I bow down. The question would be.
both of you are one side.
No, we'll assist you.
Both of
On this issue.
on this issue.
Yes, my lord. We'll
Unfortunately, both of you say that Narasimha Rao has been.
No, he tried his best, my lord, to dilute his case. But I still, my lord.
No, he also doesn't. He also doesn't.
Lord, I'm saying something slightly different.
Therefore, when a bench of 3 honorable judges,
I bow down. My lord. No further discussion on.
we must have some view of as to whether it is correctly decided or not from an independent.
Lord, let us now, my lord, go a step further. I bow down, my lord. Once there is a reference, it needs to be answered. Because that's how, my lord, the system works. That's how the discipline works. The question would be, would a bench of coordinate jurisdiction of 5 honorable judges be able to say either way that it does not?
We can say that if we are convinced that Narasimha Rao has been correctly decided, then we can close the matter. And if we find that it is not correctly decided, then only the question of
Reference may.
arise.
Then may I take my notes?
If we also have a doubt, then it has to go to sir.
Yes. That's all.
Now, therefore, now the task.
Ultimately, it is
Lordship,
what is the extent of that immunity
Lordship.
for what acts done by a member of parliament or for a member of the legislative assembly.
On the floor of the Kerala Legislative Assembly,
Yes.
by Later, the public prosecutor sought to withdraw that prosecution on the ground of immunity. That withdrawal was not allowed. Not
Sorry.
Yes,
All right,
I'm sorry.
Mr.
I was
Raju,
answering.
Mr. Raju Ramchandra, please listen to us. See, we want assistance.
Lordship, please.
Yes, yes, we'll assist.
We, Ms. Patwalia, why don't you assist the court here?
Yes.
Please, where is Gaurav Agarwal? He is here. Where is Gaurav?
No, Mr. Gaurav Agarwal is really busy as an MICA, so he will not be able
You
to.
assist Patwalia.
Yes,
You please Patwalia.
Sure.
And Patwalia, please assist us, right?
We'll do that.
Because we require the other words you have heard, you know.
I've.
Yeah.
Certainly, well, we will also assist him.
Yes, we
That,
need
that's
some
not the
assistance.
question.
If we concur with Narsir Rao, then further
Yes,
that would
yes.
not be necessary.
Absolutely,
We
absolutely.
can send back the matter to the learned 3 judges or 2 judges for deciding it on merits.
Yes.
Correct.
On merits, I am opposing him. No?
Yes.
On proposition of
We can't go into the question
Yeah,
of merit.
that's
has
on
to be
proposition
on
of the constitutional principle. I feel my Lord Narasimha Rao is rightly decided.
That is what Raju says. So, no opposition to him.
Raju unfortunately did not say, my Lord. He said many things and we went into a
No,
wrong.
no, no. He
I mean, that's not fair.
That doesn't make.
he categorically said that he is protected by Narsimha, but the learned single judge has wrongly applied Narsimha.
As a matter of fact, my Lord, as a matter of fact, my Lord, sometimes if we write a novel instead of, my Lord, a para, it is, my Lord, less effective. In a case of Kerala, which he was, my Lord, addressing, in Kerala there were hooliganism in the house, and the court said that they are not protected under 195. That was the one line which was required to
I
be.
said vandalism instead of hooliganism.
Yes, yes, but it was a novel. I am giving a paragraph.
All right, we will do that. Come, right. Come. See. Yes, but the council is requested to assist the court as an amicus curiae. Great to see full name, Gaurav Agarwal. Any initials? No.
No, he writes Gaurav Agarwal.
Only
He
Gaurav.
writes Gaurav Agarwal.
He is really Gaurav.
Gaurav Agarwal, Learned Council, Learned AOR, right? AOR is requested to assist Mr. Patwalia in this case. List this case when? January, right? After 7th.
No, December. I would request for December. I would earnestly request
Because
for
I was a party.
that doesn't matter. No? That, how does that matter? How does that?
See, I was telling my brother, just now I told him, so far I am the Karta of this bench. I will pass on the Kartaship to my brother.
No, my Lord. But my Lord,
All of us would love to have it in December.
we are the co-partners, my Lord.
We don't think that it will take more than a day.
It cannot. Should not take, my Lord. If we
Give a date.
The two perspectives, the judgments and the independent perspective of the amicus.
today itself. You need not have paper book for that. Strictly speaking, you just have to examine.
it's a question. I have not even opened on fact.
Assist to the
But I think
correctly decided or not.
I'll give a paper book to him, my Lord.
Well, 6th is all right for you?
Any day when your lordship fixes it, so.
6th is Tuesday.
That's all right.
Tuesday is all right.
Lordship, please. Lordship.
List on 6th.
Any vote.
on the lighter side. Your lordships only have the jurisdiction to grant an injunction. But here, as a karta, the co-partners, my lord, injuncted your lordships, my lord, from.
No, but
Including the co-partners here.
no.
Yes, my lord, but I can't.
Solicitor, who included you as a co-partner?
My lord, here I
Self.
no, my lord, my lord, I was only on two of us. Would wish, my lord, I can hear, but I.
No, I was just telling my learned brother that I had some objection because by the two of my learned brothers and sisters, they were conferring in some language which we both of do not understand.
Yes, that's an overwhelming majority.
That is, my lord.
All right,
I
thank you.
think, my lord, yes, my lord, all the majority can confer in a different language.
All right, we will have it.
Great.
Obliged to lord.
Karta is recognizing the lady as a co-partner.
Law has parliament has recognized.
Then now yes, of course, my lord, your ladyship can be a co-partner.
And Vinita Sharma again, I am a partner.
My lords have decided.
Elder brother is party to Vinita.
Yes, my lord.
But we have given a cut-off date, right?
Yes, but I was not including on your lordship, my lord. I was saying we are the co-partners.
Date, please.
Date, sir? Date.
Here is regarding interpretation of section 319 of the Code of Criminal Procedure.
Where is Nagamuthu? You are in this case? Not in this case?
319, Nagpattu,
You assist the court, Nagamuthu, here also. Let him hear. If you want, you can give a date also, but you let us hear, Mr. Patwale. If you want, we can take it up again tomorrow. For you, this is a very small matter, 319.
you had substantially argued it before a division bench. Result is immaterial.
All right. Yes.
May it please you. Lord, my issue is very narrow and limited. And my issue is that the order under 319 in this case was passed after the trial in the main case was over. The order itself records that by a separate judgment, I have concluded, convicted and sentenced the accused today, and then I proceed to pass this order. Now, 319 is a power which is to be exercised during inquiry or trial as per the section itself. This has been interpreted by a 5-judge bench of this court, my lord, in Hardeep Singh's case. And therefore, according to me, it is completely covered. The reference order, I'll read to your lordships, my lord, first, and then I will take your lordships to the facts of this case and my submission.
Patwale, what is the date of the reference order?
Yes, the reference order is dated 10th of May 2019. Yes, that's right. And thereafter it comes to 5 by 5th of September. First 10th May, your lordship.
And then it's a This is by, I think, learned 2 judges.
Correct. And then it went.
Thereafter, the learned 3 judges referred to a 5 judges.
Yes, and then the learned.
That is 5th of September.
Correct. The learned two honorable judges said that let it be placed before 5.
First division bench.
Correct.
The first, this is 10th May, is it? 10th May 2019.
First order, yes, is 10th May 2019.
Yes,
That's the order. That is really the mind of the judges.
All right.
Therefore, I'll read that.
Yes, we have.
These criminal appeals are filed against the impugned judgment and order of the High Court. of
1 minute, my learned.
Just one
friend,
second.
This one.
Yes.
Okay.
Yeah.
All right. Yes, we have.
My lord.
Yes.
These criminal appeals are filed against the impugned judgment and order of the High Court of Punjab and Haryana, dated 7th November 2017, passed in criminal revision number so-and-so and criminal revision number, where the High Court dismissed the criminal revision petitions and upheld the order of the trial court, summoning the accused appellants under 319 of the Code of Criminal Procedure. The factual narration of this case is that on 5th March 15, a first information report was lodged in the police station Sadar Jalalabad against 11 accused for the offence committed under sections 21, 24, 25, 27, 28, 29, 30 of the Narcotic Drugs and Psychotropic Substance Act 1985. Section 25A of the Arms Act and Section 66 of the Information Technology Act. Initially, under the first charge sheet, dated 6 September 15, 10 accused were summoned and put to trial in session case number 289 of 2015. Even though a second charge sheet was filed by the police, the same did not name the accused appellant there. Subsequently, on 31st July 17, the prosecution filed an application under 311 of CRPC for recalling PW 4 and 5, which came to be allowed. On such recall, the aforesaid witnesses named the accused appellant therein. Thereafter, the prosecution filed an application under 319 of CRPC in session case number so-and-so for summoning additional 5 accused, including the present appellant, by placing reliance on statements of PW 45 and PW 13. On 31st October 2017, the session court first pronounced the judgment in session case number 289 of 15, convicting the 9 other accused put on trial. On the same day, by a separate order, the session court, while allowing the application of the prosecution, summoned accused appellant under 319 of the CRPC. Agreed by the summoning by the session court, the accused appellant filed separate criminal revision petitions in the High Court of Punjab and Haryana, being criminal revision numbers are given. The High Court, by common judgment, impugned judgment, dismissed the revision and upheld the summoning order. Aggrieved by the impugned judgment and order of the High Court, accused appellants have approached this court through these petitions. Having heard learned counsel for parties, learned senior counsel appearing on behalf of the accused appellant in SLP number contended by relying on Hardeep Singh versus State of Punjab 14(3) SCC to state that power under 3191 can be exercised at any time after the filing of the charge sheet and before the pronouncement of the judgment. In the present case, the summoning order passed after the order of conviction is in clear breach of the principles laid down in Hardeep Singh Supra. Counsel further contended that when Hardeep Singh has clearly prescribed the stage at which an application under 319 can be entertained, the aforesaid violation is not merely procedural, but rather a substantive one. Lastly, the counsel contended that the moment the trial is concluded and matter is reserved for judgment, then the stage for exercising power under 319 ends and the court becomes functus officio. Mr. Giri, learned counsel, senior counsel appearing on behalf of the accused in the other SLP while generally supporting Mr. Patwalia, has submitted that the order summoning the appellant was passed simultaneously with the order of conviction of other accused. The counsel submitted that section 3194 has to be read along with 3191, which provides that the new person has to be tried together with the accused. The principle is based on communality of evidence. But in the present case, allowing such application under 319 goes to the root of the fair trial, as the court has already considered such evidence and proceeded to speak on it. It is the same evidence which would be reappreciated, and the inclusion of which such evidence vitiates the principle of fair trial. Learned senior counsel appearing on behalf of the state in SLP argued that even if it is assumed that the summoning order was passed subsequent to the conviction order, the relevant consideration is that application of mind was within the prescribed time under section 319. The process of application of mind and pronouncement of summoning order are separate under 319, and it is the time of application of mind which is relevant. The court further drew attention to the fact that undisputedly the application under 319 was filed and heard during the pendency of the trial, and the order thereon was reserved. In this context, counsel submitted that application under 319 was separated from the trial by direction of the High Court. That's not factually correct, but anyway, I'm reading it the way it is recorded. In this context, the counsel submitted that application under 319 was separated from the trial by direction of the High Court so as to complete the trial expeditiously in a time-bound manner. Now, the aforesaid fact cannot be used to prejudice the case of the state. Lastly, the counsel maintained that summoning order under 319 was passed on the same day, simultaneously, along with the final judgment convicting the other accused. Moreover, there is no procedural irregularity committed. Moreover, he emphasized that the trial in this case could not be said to be completed unless decision was given in respect of all the accused fully. This submission was based on the fact trial had been bifurcated and was pending in respect of the other absconding accused, which would sustain the exercise of power under Section 319. Learned senior counsel appearing on behalf of the state in SLP number so-and-so, while supporting the arguments made by learned senior counsel, further submitted that it is settled law that procedural laws must be liberally construed to render justice. Moreover, assuming but not admitted that an irregularity in exercise of power under 319 was committed by the trial court, the same would not vitiate the proceeding. The counsel concluded his arguments by stating that the finding of the trial court cannot be reversed under 456, as the appellant has not made out a case of failure of justice. In the facts and arguments presented, the following question arises. Now, whether the order of the session judge summoning the appellant hearing as additional accused was in breach of 319. If the answer to the above is in the affirmative, would the order of the courts below still be sustained under the code? At the outset, it is pertinent to note that 319 reflects two important objectives. Firstly, the court's duty to bring home the guilt of all accused and render complete justice. And secondly, the duty of the state to take every criminal prosecution to its logical end. This court in a catena of judgments has defined 319 as an enabling provision, especially in the circumstances where the investigating agency has failed to array any person as an accused. This provision empowers the courts for calling such persons to face trial. The section stipulates that a court may summon any additional accused if it appears from the evidence during the course of any inquiry or trial that such an individual, not being an accused, has committed any offense for which such person could be tried together with the named accused. Subsection 4 of Section 319 of the CRPC indicates that the proceedings with respect to the summoned individual, as per Clause 1 of 319, may be a de novo or joint trial. The appellants have argued for a comprehensive reading of 319(1), where the aspect of application of mind by the judge as well as pronouncement of the order are both bound by the prescribed time limit. They have extensively relied on Hardeep Singh to point out that trial court was functus officio and did not have the jurisdiction to deliver the order of summons. The High Court, while repelling the contention of the appellant that the trial court was functus officio when the summoning order was passed, placed reliance on the factual matrix explained later in Shashikant Singh and noted that the decision in Shashikant was on the same point rather than Hardeep Singh. In Shashikant, this court was concerned with a unique situation. The question which was before the court therein was, can a person summoned in pursuance of an order passed by a court in exercise of power conferred by 319 of the Code of Criminal Procedure be tried for the offense for which he is summoned after the conclusion of the trial wherein such an order of summoning was passed, is the question that falls for determination in this appeal. While answering the same, the two-judge bench in Shashikant held as follows. Provision cannot be interpreted to mean that since the trial in respect of a person who was before the court has concluded, with the result that newly added person cannot be tried together with the accused who was before the court when order under 3191 was passed. The order would become ineffective and inoperative, nullifying the opinion earlier formed by the court on the basis of evidence before it that the newly added person appears to have committed the offense, resulting in an order for his being brought before the court. The mandate of law of fresh trial is mandatory, where the mandate that newly added accused can be tried together with the accused is directive. The High Court has placed extensive reliance on factual matrix of Shashikant's case to draw parallels between the similarities in both cases. The summoning order in the former case, the trial has ended, whereas in this case it was passed after the trial has ended, is after the passing of judgment in session case number so-and-so. Therefore, this court, while dealing with Shashikant, interpreted the law based on the facts available therein, whereas the present case has a different context altogether. In this context, it is important to note that when Hardeep Singh's case was heard by the two-judge bench, this court took note of the findings in Shashikant's case supra. The two-judge bench observed that In Shashikant, during the pendency of trial of an accused, another person was summoned by the trial court under section 319 of the code. But by the time he could be brought before the court, the trial against the accused was over. It was held by this court that the words could be tried together with the accused in section 319 were merely directory, and if the trial against the other accused is over, such a person who was subsequently added as an accused could be tried after the conclusion of the trial of the main accused. Taking note of the above two-judge bench in Hardeep Singh, referred the matter to three-judge bench on the following question. When the power under subsection 1 of section 319 of the Code of Criminal Procedure of addition of the accused can be exercised by a court, whether application under 319 of the code is not maintainable unless cross-examination of the witness is complete. What is the test and what are the guidelines of exercising power under subsection 1 of section 319 of the code? Whether such power can be exercised only if the court is satisfied that the accused summoned in all likelihood would be convicted. Subsequently, this court in the aforesaid matter of Hardeep Singh laid down the scope and extent of the powers of the court in the criminal justice system to array any person as an accused during the course of trial as per 319. The questions which were formulated by the larger bench were, what is the stage at which power under 319 of the Code of Criminal Procedure can be exercised? Whether the word evidence used in section 319 of the Code of Criminal Procedure would only mean evidence tested by cross-examination, or the court can exercise the power under the said provision, even on the basis of statement made in the examination in chief. Whether the word evidence used in 3191 of the Code of Criminal Procedure has been used in a comprehensive sense and includes evidence collected during investigation, or the word evidence is limited to evidence recorded during trial. What is the nature of satisfaction required to invoke the power under 319 of the Code of Criminal Procedure to arraign the accused? Whether the power under 3191 of the Code can be exercised only if the court is satisfied that the accused summoned will in all likelihood be convicted? Does the power under 319 extend to persons not named in the FIR or named in the FIR but not charged? We note that the difference of formulation in the reference question and the final order of the Constitution bench with respect to question 1 makes a difference with regard to the present case. It is precisely the gap between the restricted formulation of question number 1 by the Constitution bench and question number 1 in the reference order of Hardeep Singh, which these unique facts fit in. The earlier question number 1 in the reference order was broader in comparison to reformulated question by the Constitution bench. It is this marginal area which is sub silento, which needs to be referred to a larger bench. Again, in Hardeep Singh, the Constitution bench set out to answer the questions referred above. In this part, we are mostly concerned with the first question. The court, while assessing the ambit of the term trial, was concerned with the stage during which the power under 319 could be exercised. In this regard, it was held, since after the filing of the charge sheet, the court reaches the stage of inquiry, and as soon as the charges, the trial commences, and therefore the power under 319 can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during the stage of section 2078 Code of Criminal Procedure, committal, etc., which is only a pre-trial stage intended to put the process into motion. This stage cannot be said to be a judicial step in the true sense, for it only requires an application of mind rather than a judicial application of mind. It was contended that the question of law here is unique to the present case, and the earlier judgment of Hardeep Singh did not have an opportunity to cast any light about the validity of the summoning orders pronounced after the passing of the judgment. They further argued that Hardeep Singh treats 309 in an isolated manner without taking into consideration the spirit and mandate of the court. To strengthen the aforesaid submission, the state further 465 was introduced to provide for a balanced mechanism under the criminal justice system to stop courts from getting into hyper-technicalities and committing serious violations. Court in Hardeep Singh has not considered the above principles or the issue that could possibly arise before the trial court while dealing with application under 319. The state therefore submitted that 319 should not be treated as an isolated island, should be given a pragmatic interpretation by keeping in view the entire mandate of the court to render complete justice. Needs to be determined whether trial is said to be fully concluded, even if the bifurcated trial in respect of absconding accused is still pending consideration. The appellant herein contended that observations made in Hardeep Singh cannot be diluted by a bench of this type. We have considered the averments made by the council on behalf of both the parties. We feel it would be appropriate to place the same for consideration before a larger bench. However, we are of the considered opinion that power under 319 being extraordinary in nature, the trial court should be cautious while summoning the accused to avoid complexities to ensure fair trial. We must remind ourselves that timely disposal of matters furthers the interest of justice. After perusing the relevant facts and circumstances, following substantial questions of law arise: whether the trial court has power under 319 of CRPC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of conviction rendered on the same date before pronouncing the summoning order. Whether the trial court has power under 319 for summoning additional accused when the trial in respect of certain other absconding accused is ongoing pending, having been bifurcated from the main trial. What are the guidelines that the competent court must follow while exercising power under 319? Then the matter should be placed before the Honorable Chief Justice. Then 5th September, the court said that it should go before.
Mr. Patwalia, therefore, once the judgment is reserved and before its pronouncement, as per Hardeep Singh, 319 can be applied. Now, that proposition is doubted in this case, right? Or what exactly is the point you want to?
The point is, after judgment is pronounced, according to me.
No, Hardeep Singh governs what situation?
Hardeep Singh says very clearly that Hardeep Singh interprets 319. The words of, let me just read 319 to your lordships first of all. Let me just read 319. Yes. According to me, my lord, my case is crystal clear, completely covered by what Hardeep Singh says. And this whole argument that application of mind time has to be seen is neither here nor there, because application of mind, it's the order of the court. Application of mind can be if the court has applied mind and deferred it and then ultimately decided it at a later stage. So just let me read 319. 319 is crystal clear. It was referred for interpretation and Hardeep Singh is consistently followed by courts thereafter. There are judgments of this honorable court consistently following Hardeep Singh, and according to me, I am in no grey area. My case is completely covered by Hardeep Singh's view. But anyway, let me
before that, just tell us some basic facts in your case.
Yes.
Basic facts, then we will come to
319. Let me just read 319 and then I'll go to the basic facts. Power, 319 says, power to proceed against other persons appearing to be guilty of offence, where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person should be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed. So the crucial words are, where in the course of any inquiry into or trial of an offence. That's the stage at which 319 can be used. Now, my lord, just kindly have one or two other sections, my lord. Just kindly see here itself, section 353.
What, 3?
53.
353.
Dealing with judgment.
Yes, we have.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of trial or at some subsequent time. So, when the matter is kept for judgment, it is after termination of trial and it can be pronounced immediately or he can fix a date for pronouncement of judgment. But trial is over at that point of time. And what happens after judgment is pronounced is 362. Just this link will be complete. 362. The court will become functus officio. That is why your lordship says no review, no other application except clerical mistake, etc. Kindly have 362.
Yes.
Court not to alter judgment, save as provided by this court or any other law for the time being in force. No court, when it has signed its judgment or final order after disposing of the case, shall alter or review the same, except to correct a clerical or arithmetical error. Your lordships have interpreted this to mean that after pronouncement, court is actually functus officio. I have made a note on that. I'll just be passing it over. Now, what is my case? But I have just made this pass on.
And even review is not permissible here.
In criminal law, yes. But I have just made, just if I
To a certain extent, 482 applicable.
yes. Just kindly see this list of dates. I'll tell your lordships in my own words.
Basic facts we should know.
Yes. I'm going to give your lordship the facts. And in fact, there is a huge, this one, I am also a politician. What has happened in this case, I'll give your lordships a broad overview and then I'll make out my case. I come from a political family in the state of Punjab. My father was an education minister in the earlier years. Of course, now he is no more. I actually contested elections for the last 2-3 decades. Earlier, I contested with the Congress. Then I became leader of opposition in the Aam Aadmi Party. When this whole episode happened, I was leader of opposition of the Aam Aadmi Party. I was exposing all these sand scams and other scams. This is my pleaded case. It's not something out of the pleadings. So I was exposing all these scams. Now what happens is that on 5th March 2015, and if your lordship will have page 1, I'll just quickly take your lordship through this list of dates, and then I just quickly, and then because depending on whether I had other arguments of malafide, etc. So if your lordship in this combination will examine only my first submission.
No, we are only considering the referred question.
All right.
Rest of all, I think it has to go back to
back. So then I will give your lordships broadly the factual basis and in the setting in which the case arises, and then go to the referred question straight away. So after giving your lordship broadly the setting in which the case is arising and what actually happened, so that your lordship has an overview. So my lord, on 5th of March 2015, an FIR is lodged under the NDPS Act and under the Arms Act, etc. A total of at police station Sadar Jalalabad, district Fazilka, against 11 accused persons for heroin trade. Now there are total of 8 persons are arrested, including one Gurdev Singh of Bholanath constituency, ex-Sarpanch. I contest elections from this constituency, my lord, Bholanath. Sarpanch and ex-chairman market committee. Alleged recoveries are made from them. The petitioner is not named in the FIR, nor any overt or covert act is attributed to the petitioner. A special investigation team is constituted on 9th March 2015 through the IG Bathinda zone to supervise the investigation in the present case. That SIT is headed by the DIG Firozpur, SSP Fazilka and SP Fazilka as its members. According to me, the sole purpose of this SIT is to dig out some way to connect me with this crime. Now, the SIT gathers some phone call records of Gurdev Singh with Joga Singh and Manish Kumar. Joga Singh is my private security PSO and Manish Kumar is my PA. They are petitioners in the second petition, which is also before your lordships. That is 503.1. Gurdev Singh belongs to the constituency of Sukhpal Singh Khera, petitioner. On 10th March 2015, various news items appear in the media quoting the SIT members as saying that phone calls between the petitioner and Gurdev Singh and making derogatory remarks against the petitioner. Now on 4th May 2015, in view of the apprehension of being falsely implicated, Sukhpal Khera approaches the High Court by filing a criminal writ petition number 8999 of 2015. The prayer I have reproduced at page M of that petition. I said, transfer this investigation to CBI. Prayer 1. Prayer 2, I said, please protect me from arrest. Prayer 3, I said, in case I am to be arrested, give me 1 month's notice. And prayer 4 is another miscellaneous prayer that I had made. These were the 4 prayers. Now, my lord, what happens? On 6 September 2015, challan is filed against 9 persons, since 2 were declared proclaimed offenders and one of them was never apprehended. So the trial actually is against 11, but initial challan is only against 9 because 2 are declared proclaimed offenders. Now, thereafter, my lord, the investigating agency files an affidavit through the SSP Fazilka and writ petition number so and so. That is my writ petition. Now, this is very crucial, extremely crucial. On 6th July 2016, evidence of PW4, that is Ajmer Singh DSP, and PW5 Jaspant Singh Inspector was completed, and a request by the prosecution for recalling on the same day is declined by the trial. So these 2 persons, Ajmer Singh and Jaswant Singh, who will ultimately then come back by a 311 application, they tender their evidence. In their evidence, they talk about me, but they do not say I am in any way connected with the crime. If need be, I'll show that to your lordship.
What do you mean by talk about you?
They say that yes, a question is put to them by the accused that this whole thing is politically motivated, that the accused are connected with Sukhpal Khera, and therefore they are being implicated falsely due to their connection with Sukhpal Khera by the then Deputy Chief Minister, who is also named, my lord, in that examination and cross-examination. Both of them do not implicate me in the crime at all, and I will read it if need be. Then I'll just complete the things. In May, this evidence takes place, my lord, in July 2016. In May then after this, there is a first supplementary charge sheet against one of the 2 absconding accused. He's detained, and therefore there is a supplementary charge sheet against him. Then the trial proceeds. By 31st July 2017, evidence of almost all other witnesses is over. Then if your lordship will just have the very last page of this list of dates. Just this, what I've given. Just kindly have the very last page. Page 26. Just see these dates, how the matter proceeds. So 6 September 2015, your lordship has that date or not? 6 September 2015 is the charge sheet against the 9 original persons. 18th October 2016 is the first supplementary charge sheet against that one of the absconding accused who is then caught. 28th May 2017 is the mining scam raised by me in the newspapers. One minister has to resign as a result of that. It becomes a huge scandal and a big issue in the state. In my rejoinder, I have placed those newspapers on the record. Now, my lord, it is then that on 20th July 2017, a second supplementary charge sheet is filed. The second supplementary charge sheet does not say anything, but is only filed for the purpose of placing on record some alleged call records of conversations between Gurdev Singh, his sister Charanjit Kaur, between, they say, me and my PS. That's the sole purpose of this second supplementary charge. After this second supplementary charge sheet is filed on 20th July, hot on heels, 31st July 2017, an application is filed for recalling of those 2 persons, PW4 and 5. The reason, those 2 police officers, the reason given in the application is their conversation with the accused and the call records have to be connected with the accused. That's the reason in the application for recall. Recall originally had been declined. I had read to your lordships. This recall application is allowed on 17th August 2017. On 14th September 2017, these 2 witnesses are re-examined. In their 2-3 pages of re-examination, they do not talk about any other accused. Their whole evidence is about linking me with the call records and Gurdev Singh. Now, that original statement turns curtain. And that's the whole purpose of their examination on this 14th September 2017. Then, my lord, on 21st September, they get one more person to say, I have got records from the telephone companies regarding those calls. He is asked to state that, have you got a 65B certificate? He says, I don't have a 65B certificate. In the evidence, in the written statement filed here, 2 undated 65B certificates are produced by the state, just pushed in. So I have an issue about that. Then, my lord, so after 14th September, 21st September, when this evidence, according to me, in commas, is procured against me, through persons who had already testified and never blamed me, this application under 319 is filed on 21st September and shortly it is allowed, and that is how I am made an accused in the trial. So one of my main...
What is the date on which the application is allowed?
Yes, the date on which the application is allowed is 31st October 2017.
What date? What date?
31st October 2017, the same day when the judgment is pronounced of conviction and sentence. So, my lord, according to him, Hardeep Singh also says what kind of evidence is required. And I had addressed at great length about the fact that, leave aside my first submission, this evidence is completely procured to fix me. And therefore, my lord, that is one of my main submissions. But in any case,
That is on the merits of the matter.
That's-
We have to...
I just wanted to give your lordships a sort of a setting. And what do they say? How are they linking me? They say the same two officers who came. They say when these...
Particularly, again, we can't go into the merits of the matter.
But I'm just
We
giving
have
your
to examine
lordships.
as to whether...
In the next 5 minutes, I'm just going to give your lordships a little flavor of what I am facing. So that's all, and then I'll come to the questions. I have prepared several.
We are called upon to answer some question and we have to limit ourselves to that.
All.
This is my submission, my lord. In fact, it is only a reference. So, my lords are contemplating about the reference only. As far as the merits are concerned, my lord, that will be seen by...
That is what I have said.
Grateful, so grateful, so grateful.
Yes. Yes, Mr. Patwalia.
Flavor, so that our appetite...
So I just before lunch, my lord, so
Some food for thought.
So just two more lines and I finished. Two more. Because not his whole life, it's a life-changing situation for him. He was the leader of the opposition. He had to resign. He had to quit. His family is one of the premier families in the state. It's smeared on the basis. Now, what happens interestingly more? On the basis of this FIR now, there is a PMLA against me.
Just trying to define the meaning of premier family.
I was just telling my brother,
It's beyond
my learned brother, in Punjab, premier family would mean family like Mr. Patwalia.
I'm grateful, my lord, but unfortunately, we are far away from politics, my lord. So, or fortunately, I should say. So, my lord, they are asked, what is the basis? They say, we actually interrogated them when they were arrested. So, what do you have to show? They show 5-6 loose pages of white paper. 5-6 loose pages. In cross, they are put, is this on the case diary format? They say no. Is this numbered? No. Did you produce it anywhere? No. So 7-8 loose white pages, sheets of cross-examination are the basis of all. So, my lord, that is how, therefore, I am now, I then, after that, I went in revision before the High Court. High Court rejected it, ultimately saying that High Court basically said two things. High Court relied on Shrikant, but the reference order itself put Shrikant out of the picture by saying Shrikant was on a totally different factual situation, because in Shrikant, the order under 319 was made admittedly during the pendency of the trial. But because
Patwalia, if the trial court had allowed 319 application before the pronouncement of the judgment, perhaps you had no case according.
on my first point, yes.
No, merits, we are not examining
Yes,
facts.
yes.
You had no problem. You had no problem.
I would not have been able to argue that that Hardeep Singh's is violated. Yes, your lordship is right.
All right. Now, judgment was pronounced on the same day this 319 application was allowed.
Correct.
Before the pronouncement of the judgment, if 319 is allowed and then judgment is pronounced, what objection do you have?
Well, then I could have had an objection, because once the judgment, the trial was over earlier. The trial had been concluded, matter was kept for judgment, and therefore, by virtue of 353, therefore the court could not have done it.
Well, with my lord's permission, only one thing. Well, Hardeep Singh, which my friend is relying upon, says till pronouncement. I can read that. It is not conclusion of trial. Hardeep Singh says till pronouncement. So I'll refer to the paragraph. He's relying
I
upon.
will also read it, my lord. Let my friend not be very anxious.
No, I'm just saying the Hardeep Singh you are relying upon, that says till.
So therefore, your lordship put me a question. It says inquiry or trial. According to me,
His contention appears.
we want to ask. Now, judgment is pronounced. Thereafter, 319 application is allowed. Assume in a given case. Now, that has to be separately numbered, is it? What is the procedure there?
So I'll tell your lordship what happened.
What happens there?
Well, in the present case,
We are
it was already
also-
separated.
Same case can't continue. Same case can't continue.
Well, in the present case, it
We
was
are
already
before
separated.
constitution
It was already separated. In the present case, it was already separated. 319, Malad, the Honorable High Court ordered the stay of the proceedings in the other case. So the learned trial court separated this application from the main case. So it was already separated and segregated,
Which makes
bifurcated from
it
the trial.
worse. But I will answer your lordship.
No, why we are asking? There is
I am
some,
answering
there is
that
some
question.
purpose. Patwala, please listen to. You can answer it too.
Yeah, no difficulty.
Now, for example, supposing if an accused is absconding,
Correct.
trial can't stop. What happens?
I'll answer that. In this case, one accused is absconding.
What has happened?
Now, in this absconding,
Trial is separated.
no,
And
there
it
is
will
no-
be tried
there-
separately.
No. In this case, one accused is absconding. On the date when my application was allowed, there was no trial pending regarding him because no charge sheet had been filed in his case. It was still at the stage of investigation. So therefore, that's crucial. It's a very pertinent question here. There were 9 accused to put on trial initially. 2 were absconding. One of the 2 was then arrested. For him, charge sheet was filed, first supplementary charge sheet. For the second absconding, on the date when my application was allowed, there was no charge sheet. There was no trial pending. So therefore, what the court had to do, when the court allows my application under 319, the court gives a further direction to the police to file a supplementary charge sheet against me. That direction, the High Court, while dismissing my revision, quashes that direction, saying such a direction could not have been given. So therefore,
Charge sheet cannot be filed against you, then how can?
Yes, it cannot.
so there can be no direction to file a charge sheet, is the view taken by the High Court.
That would lead to an anomalous situation.
No, that's the correct the position in law. High Court.
No. If the High Court has caused the direction to file a charge sheet,
Correct.
and also on the other hand, granted permission to conduct a trial against you. So can there be a trial without a charge sheet?
Yes, that's precisely the point. Therefore, this 319, Mr. Gai, please allow me to finish.
It is all right. I'm just putting my facts forth.
We will hear you, sir.
Oh, so great. So grateful. So
We will
great.
hear you, sir. We will-
I'm just putting the facts right. That is all.
We will hear you.
I don't give any wrong.
No, I am not
facts,
saying that at all. I'm not saying, I'm adding to what
I
you
have
said.
no intention
Mr.
of
Patwali, I'm just adding to your facts. I can change my,
2 o'clock.
well, it is always better, well, it is always better to argue before, not before an empty stomach, honorable judges.
It's we have some decorum. So, my lord, therefore, the answer to your lordship's question. Therefore, it is even
to learn decorum from Mr. Patwali.
Therefore, it is even more important that this 319 should be allowed when the trial is still pending. Because if you allow it after trial is concluded, you cannot give a mandate to the police to necessarily file a charge sheet. Therefore, it will reach a...
We consider it true.
Yes.
Yes, it becomes as a case.
Please take it. Nagamati also. Supposing if you direct him to file a charge sheet itself without an investigation,
Absolutely.
is it permissible? You are presupposing, the judge presupposes that he is an accused.
So, therefore, my
That is
lord,
why-
It requires an investigation, if I am right, assuming it to be so under
let me
170.
answer your lordship.
Well, with respect, my lord.
Let me answer your lordship's question.
Subsection 4.
Therefore, my lord,
Yes.
319 necessarily has to be allowed when there is some trial pending. Because it cannot be allowed in a situation when there is no trial pending. In my case, on the date when my 319 was allowed, there was 0 trial pending. I could have imagined if there was a trial pending against the absconding accused, still there would have been a trial pending. Therefore, my lord, the point is...
No, the trial insofar as a absconding accused is still pending in your case.
It's not, it was on that day not pending. Subsequently, I am told a charge sheet was filed in 2019 against that absconding accused. So in 2019, it is a fresh trial with a separate number of 2019. My application has been allowed in an earlier trial, which was not pending on that day. Therefore, the question was of filing a direction to file a supplementary charge sheet.
There would be a split up trial.
All right, we will come back.
Yes, yes.
Okay. Very interesting question.
Correct, correct. Grateful. Not my, the application impeding me as an.
You had filed an application, we will straight away dismiss your case.
Just so that your lordship can possibly make a note, my application under 319 was allowed in session case number 289 of.
Your application or application implementing you?
Sorry, not my, the application impeding me as an.
You had filed an application, we will straight away dismiss your case.
Right. So that application was allowed in session case number 289 of 2015.
That was not pending on that date.
Correct. The case against that one absconding accused, the charge sheet against him is filed on 3rd September 2019. And that case is now session case number 217 of 2019. My application, if at all I lose everywhere, has now to proceed in session case of 15, which today is no longer pending. So therefore, that is the factual position where things stand. Now, my lord, I think I should take your lordship to Hardeep Singh straight away. But before that, just one provision I want to point out, I could not point out. Just kindly have section 437, subsection 7. There are other also which give stages where a particular thing can be done under the criminal procedure code. I will by tomorrow put them on a single piece of paper and then hand them over to your lordships. But just see, relevant to the point here, 437 subsection 7. If at any time, after the conclusion of trial of a person accused of a non-bailable offence, and before judgment is delivered, the court is of the opinion that there are reasonable grounds for believing that the accused is not guilty of any such offence, it shall release the accused if he is in custody on execution by him of a bond without show. So after conclusion of trial, but before judgment is delivered. So the code makes a distinction as to when the trial concludes. And actually, Hardeep Singh saying that before pronouncement of judgment really has to be read to mean till conclusion of trial, because now just kindly see here itself 319. 319, the section is very clear. And therefore, my lord, it cannot be stretched to any other interpretation. 319 says.
You already read.
Yes, it says that in the course of any inquiry into or trial of another. That's the stage. Now, there are one or two reasons which it's very important that this should happen when the trial is pending. First is that question of charge sheet being filed or not. Because if the trial is pending, there is no requirement of a supplementary charge sheet. Because in other judgments, where the question was whether a person who is arraigned as an accused under 319 can apply for discharge or not, your lordships have held he cannot apply for discharge. Because he is a different kind of accused who has been actually made an accused on the basis of evidence by the court itself, and therefore there is no question of the provision of discharge applying to him. So therefore there is similarly, then the charge would probably procedurally, we were discussing, procedurally then the charge would be amended to include him in the charge, because then the court has already charged him and said that you are also, I feel you are also guilty of this offence. So the charge would be amended and the trial would proceed. And therefore, he is entitled to cross-examine those witnesses. Then that cross-examination which he does, that evidence will be utilized for the benefit of or to the detriment of all accused. So therefore, my lord, it's very important that technically now, arguing against myself, today also there is a trial pending 217 of 19. On the basis of evidence in that trial, again the state may have a right to make an application, which is a separate issue altogether. But the question is that where a trial has concluded. Now, my lord, two orders I want your lordships to see before I go to Hardeep Singh straight away. First, I want your lordship to see the relevant part of the order passed under 319 in my case. And then, my lord, there is one order which the other side realized that 319 had been separated from the main trial. I'll read that order also to your lordships. The order, my lord, in the 319 application is at page 121 of the paper, volume 1, annexure P11. To the extent that it is relevant for the submissions which are being made before your lordships in the constitution bench, it is at page 130. That's all. On merits, it may not be relevant. When I argue merits, I will show the merits there. But kindly have page 130. As
Things stand out.
correct. As things stand out, this FIR number 35 was registered and challan against 10 accused was presenting by mentioning that after investigating the challan against the remaining accused will also be filed. But till date, no challan is presented against accused whose names are mentioned in the application under 319 CRPC. By my separate judgment, all accused against whom challan was presented, except one, are convicted today. So this is being done after that judgment is passed. Whether it is done on the same day or after 10 days, the legal consequence, in my respectful opinion, will be the same. So the learned judge is recorded, by my separate judgment, all accused against whom the challan was presented, except one, are convicted today. The proceeding of this application was separated from the main challan because the High Court in the main challan had directed this court to decide the case up to 8th November 2017, then call detail, etc., etc. Then at the bottom of the page, he says, the learned judge says, as discussed above, I am satisfied there is every likelihood that accused Sukhpal Singh, Kheda, Joga Singh, etc. are likely to be convicted if allegations are not rebutted. Further, while filing the challan, it was mentioned that after completing the investigation, challan against these accused will be filed. Same is not filed by the police. To my mind, accused must be summoned to face the trial and rebut the allegation. Then, my lord, page 132, last 4 or 5 lines. Two things the court says. Prosecution is directed to file the supplementary challan against these accused. Steno of this court is directed to print out 2 copies of this order. One to be placed on this file and attached to the main file. Ahmed is directed so-and-so. Non-bailable warrants of these accused be issued for the next date of hearing. This part of the order, direction to file supplementary challan and issuance of non-bailable warrant, is set aside by the High Court, even while my revision against the main order is rejected. And that part is at page 30 of this very paper. Actually, page 29, if I can read. Bottom. Page 29 at the bottom. The next submission made by the learned senior counsel for the petitioners is that the trial court could not have directed filing of supplementary challan, as the trial court does not have such power as held by the apex court in some decisions. I have no doubt in my mind that the law is straight, that the court does not have power to order filing of a supplementary charge sheet. But then there are peculiar facts in the present case. When the challan was filed before the trial court by the special investigation team, it was specifically stated as under regarding reserving its right to file supplementary challan. In connection to absconding persons and suspected persons, investigation is going on. Permission under the Arms Act has been sought from worthy DM and is annexed with this challan. Upon completion of investigation against absconding and suspected persons, supplementary challan shall be submitted under 173A. It is settled legal position that filing of supplementary challan one or in multiples is permissible under 173 Code of Criminal Procedure. To contend that first supplementary challan was filed and in that the petitioners were not named would be no answer because the authority to file one more supplementary charge sheet of the investigating machinery has not been taken away. Therefore, the investigating agency is entitled to file supplementary charge sheet. As stated by me, the direction to file supplementary charge sheet will have to be read down in the order impugned as the liberty to the investigating agency to file supplementary charge sheet if they want. Accordingly, the said part of the order will have to be modified to bring it in consonance with the settled legal position, which I will do hereinafter. The next submission made by the counsel for the petitioner that the trial court could not have issued non-bailable warrant against the accused must be upheld. It is well settled position that such a course of action should not be pressed into service. The trial court has not recorded a single reason as to why instead of issuing summon, straightaway warrants have been issued. I think the trial court has overdone it. It was not justified. Hence, the part of the order issuing non-bailable warrants is set aside. Then the ultimate order is brought. That order 2I. The order directing filing of supplementary charge sheet is modified and shall be read as under. Liberty is reserved in favor of the investigating agency to file supplementary charge sheet against the additional accused person, if so advised, and the order for issuing non-bailable warrants is also set aside. Then, my lord, there is one order where the trial is separated. Okay. That is the annexure R3 with a written statement filed by the state with a counter affidavit at page 245 of the paper.
You put second one.
No, counter affidavit.
Counter.
Counter.
Yes, they simply wait. Only will that company reach out.
When it's company, to be made to run computer.
145. I have no notice is issued to me at any stage of the 319 application. It is only after the application is allowed that non-bailable warrant was issued, which was then High Court had read it down, and therefore I challenge that order. So at the stage when this order at 245 is being passed,
At what stage 319 application was filed? At what stage of the trial?
it was filed when the entire evidence was over. If your lordship will have that last page of the
Who filed that application?
State of Punjab.
State, is it?
Yes. It was filed at a stage when the entire evidence was over.
After conclusion of the trial.
I have in fact given that, my lord. In fact, application was filed
There must be
on 21st September 2019. In the normal course, the entire evidence was over by 31st July 2017, except one formal witness, which was a Patwari, which had to be examined. Thereafter, the second supplement, if your lordship will have page 26 of my note, which I have given just. The last page. It was a forced application. It was the evidence was created and then the application is filed. In fact, my lord, I just want to read this.
What do you mean by created, Mr. Patwalia?
Two witnesses who had already been examined and who said nothing about me are then recalled by moving a 311 application. In the recall application, the reason given for recalling those witnesses is we want to connect the call records, which we are now filing with a supplementary charge sheet, with the accused already arraigned in this case. That's the reason given in the 311 application for recalling those witnesses. That the call records which we are filing in our second supplementary charge sheet on 20th July 17, when almost entire evidence is over. The call records are of 2015 onwards, which was already with them. So then they say, we are filing this, the 311 application is filed saying, in the supplementary charge sheet which we have filed 10 days ago, 311 application is filed on 31st July. 20th July is the supplementary charge sheet. 311 application says, in the supplementary charge sheet which we filed 10 days ago, we have placed call records. We want to re-examine these two witnesses to connect those call records with the already existing accused. That application is allowed by the trial court on 17th August 2017 by recording this submission, which I am orally telling your lordship, that these call records are to be connected with the existing accused. That order is on the record. I can read it just now. Then when that application is allowed on that basis, these two witnesses come back for re-examination. In their re-examination of 2 pages, they don't utter a single word about the existing accused. The entire re-examination is connecting call records with me by relying on investigation and case diaries when the accused were in custody of the police. Now that evidence is, according to me, not admissible at all, but that's a separate issue.
All right.
So
We
then,
need not go into all those.
no,
Only
therefore,
you have to answer the question.
after those two witnesses are recalled and examined on 14th September 2017, within the next 7 days, examined on the same day. So the two witnesses are examined on 14th September 17. A third witness is examined on 21st September 17, who says, I have got this information from those Airtel and those service providers. He is asked, have you got a 65B certificate? They say no. 2 certificates have suddenly appeared in the counter. But his examination is 21st September. The very same day this 319 is filed by the state. On 21st, relying only on this re-examination of 4-5 and PW13 who is examined a week ago. That's all they rely on. And then that application is allowed. So I am not a party there at that point of time. No notice is issued. But I must tell you a lot.
There is a judgment of this court which says that notice is not necessary.
Malord, there is actually...
Mr. Nagpal
Malord, actually there is a judgment of this court of the division bench which says notice should be issued. I am a little doubtful about whether it is laying down law which is correct or not. It says notice should be issued. And that judgment actually is from the Karnataka jurisdiction. Relying on that judgment, there is a revision order of Karnataka High Court giving general instructions to all the session judges in the state of Karnataka that before you allow a 319, you must issue notice to all. In fact, if your lordship wants, that judgment is reported as 2015 9 SCC 244. That judgment lays down 2 propositions. One, of course, according to me, is completely correct. The second, I am not getting into at the moment. The one proposition it lays down is the main issue that arose was whether a accused who is arraigned under 319 can file an application for discharge. So the view which your lordship takes is such an accused cannot file an application for discharge. Correct. That's right. Because already on the basis of evidence, he has been arraigned as an accused. But that judgment equally takes a view that he must get notice. Now, I am very happy, my lord. This alone is enough to set aside my order. It is without notice. But anyway, I am not for the time being relying here on that, my lord. And I am not going to make that submission also because we are, I feel I am much stronger on other issues, my lord. The quality.
All right, now on these dates, you say 21/9/2017, PW 13 was examined.
Correct.
After that, it was posted for judgment. When was it posted? The date is not given.
31st, it is posted for judgment.
When was it posted for judgment?
All right. So 5th October, the defense evidence is closed. 5th October.
No, there's a order. I can just point out the dates while it's been with me.
No, we are asking what?
6th. When
Defense evidence closed.
Your 313, their 313 must have been recorded on 510.
4th of October. 4th October 2017, 313 is recorded. On 10th October and 16th October, cross-examination is done, and then the defense is closed. And matter is posted for judgment. And ultimately, the judgment is announced on.
Now, when was it posted for judgment?
I have those Zimini orders. But we have placed them on record. I just tell you a lot. All those orders are on the record. We had placed them. If your lordship will have page 545. The Zimini orders are all there, if your lordship will have page 545, just show it to me, of your lordship's paperwork.
545 is what? Second volume?
Second volume, I suppose. Second volume. SLP paper.
This is a document filed by the state of Punjab. It is numbered as volume 5. Actually, this matter was heard for days and days before the division bench. Everything, Chalan was filed, everything was filed. It was heard at a great length, in fact. Every document was placed on the record, everything was done. So this is, volume 2 of the state. Anyway, I can read it. I'll just read it, it's a short order. This is an order dated
Just give us the date.
31st October 2017.
That is the date of the judgment, you said.
This is the date of the judgment.
No, the day on which it was posted for judgment.
1 minute.
After trial.
Trial court must have passed the order that trial concluded,
Yes.
For judgment.
reserved for judgment.
That date you tell us.
30th October. Where is that?
No, 31st. In the course of
Defense evidence. And then
Then it is said for now to come up for 31st for arguments, and on 31st minute the arguments are heard, and then the judgment pronounced.
the order of 31st is no DW is present, neither opted to be examined. Arguments heard, filed by separate detailed judgment of the even day. Accused so and so, so and so, so and so are convicted under NDPS Act, whereas accused
Same day.
acquitted.
No.
Same date.
No.
Same
Just tell us one thing. It was reserved for judgment on 31st and same day it is pronounced.
No,
It was never
reserved.
It was never reserved. It was never reserved. 31st minute the arguments are heard and pronounced.
And pronounced.
Please.
Dictated.
Open court dictation.
Or was the reason later given?
Well, general, well, it's a white separate order. The court.
No. We are asking you.
Please.
Was it an open court dictation?
No.
That means it was prepared before reserving, is it?
Well, the judgment is pronounced, the order is pronounced, and thereafter the judgment is released. So, it is normally the pronouncement on the.
It has to be.
Well, what is, because the copy has to be supplied to the accused. Normally it should be reserved and then the copy, because the copy has to be supplied to the
It
accused.
says last
who is
line
sent in
of this
custody.
Last
So
line of this very order says copy of judgment
When
provided to the accused free of cost.
Yes, it has to be supplied.
31st October, arguments were being heard.
Yes.
And on the same day, reserved and immediately pronounced.
Pronounced.
In other words, before conclusion of the argument, judgment was prepared.
Well, it is it is
How
not
many
there.
page judgment? How many page
Well,
judgment?
I'll just refer to.
Volume 3.
Or
The judgment is in volume 3. Just check.
Otherwise, it has to be dictated in open court.
It's a 120 page judgment. 120 pages.
Overnight.
In volume 3, the judgment is there.
Overnight.
But normally,
Or was it the last portion was pronounced and the later reasons were supplied?
normally what happens, the arguments, may I just,
Give the judgment immediately.
it has to be given, a copy has to be given to the accused who's sent in custody. Normally what happens, the arguments are being heard daily, then finally pronounced. This is what normally the trial court are well aware. I'm just saying. So normally all days the arguments are heard and then finally pronounced and the copy is to be given to the accused who is sent in custody.
That way, see now, if somebody initially the trial.
As far as the judgment and the reference is concerned, that is entirely different, but I'll bring to the honorable notice of the honorable court.
One in the High Court, you can't pronounce the judgment and say reasons to follow.
Please. The learned trial court, normally they keep on hearing the arguments and then finally pronounced on that day and finally heard on the sentence also, which they have to hear.
No, because an opportunity, even after recording an order of conviction,
Please.
an opportunity has to be given to
It has to be given. It has been given. It has been given. What is done is a judgment is passed regarding the conviction.
There's some anxiety. If it is closed on 31st,
Please.
and a 120-page judgment pronounced on the same day, it would have been a different matter that the learned judge would have finished the arguments on 31st and then started dictating the judgment in the open court. And it could have gone for a day or day two and then that judgment would have been pronounced in the presence of the accused. And thereafter he would ought to have been given an opportunity to hear him on sentence.
Yes, this is
a 120-page judgment, as my learned senior brother expressed.
Rightly,
was it drafted even prior to the arguments or what?
What the learned trial courts, Mr. Patwalia, just what the learned trial courts normally do is, they hear
that when the court is,
what the learned trial courts generally do is, with the arguments going on, they keep on writing the judgment so that it is pronounced and then for sentence.
Never done.
Normally, this is what.
Then you are not applying your mind to the
with the arguments, this is. That will be regarding if they challenge the judgment.
Not a reason judgment at all. You are not applying your mind to the
then that will be regarding the judgment.
The last word is argued. It should be okay.
It should be, it should be. Normally, it should be, and it should always be.
Now, what happened to that judgment? Is it an appeal now?
Yes, so that will be decided as an appeal. That is an appeal before the Honorable High Court. So that judgment is before the Honorable High Court. My friend is not interested in that at all because that is for the other accused.
Anyway, they must have got message by now.
They must have. That is still pending decision in the Honorable High Court. As far as this case is concerned, the reference is entirely different.
Out of just curiosity, because
definitely. Because I also asked my colleague, this is 120-page judgment. That is what I asked. The judgment is 120. So some seems to be very efficient. Learned trial court.
We have our own doubts with highest amount of efficiency. Can such a judgment be ready within an hour or two?
In fact, the
unless
not closed till then. So, it is up.
All right, Patwalia, please continue.
So great. So,
please continue.
So, what happens is that on 31st, by a Zimini order, he says no DW present. Arguments heard, concluded. 31st, he pronounces this 120-page judgment. 31st itself, he says, just kindly have this volume. It's very interesting. Just kindly have this volume of the judgment. It's volume R3.
Same one. 31 and 31. Evidence last attempt.
The Zimini order of 31st says no DW present. Arguments heard.
What page you are?
Just R3. Just kindly have page 109, which is the last page of the judgment. And just kindly see, all witnesses carefully examined, carefully considered, they're recorded, and then have 109.
Yes, we have.
It is proved on the file that accused Shanti and Nirmal possessed non-commercial quantity, so they are convicted, etc. So conviction is recorded. Then 110 quantum of sentence also on the same day. Heard on the question of quantifying sentence to be awarded, and then quantum of sentence on the same day. And on the same day, then he decides the 319 also. After doing all this. And there is not a word of 319 in either of these two. There is not a word regarding the 319 application in either of these two.
As your learned advocate general says, the judicial officer appears to be very efficient.
Well, it seems to be. And that is not, of course, reference is entirely different. The reference is entirely different.
I respectfully submit, Lord. This at least shows the amount of application of mind, or rather the non-application of mind in which the entire...
That will be argued in appeal, Lord. That will be argued in appeal as far as 319 is concerned. Lord, the reference is only for a particular... My friend has not argued on the reference at all. On merits, Lord, he is arguing, which is not before this honorable court. Of course, Malets can go through that.
No, we wanted to know certain
Yes.
facts, no?
So, Lord,
Course of our
with respect, Lord, why... Sorry.
All right.
So, Lord,
judgment.
So, my lord, my respectful submission is, even so far as the order under 319 is concerned, is on the same day, and therefore your lordship can well imagine the application of mind, of judicial mind, when you are passing such an important order, where you are actually taking away the liberty and altering the course of the life of an individual very substantially. After all, it's a prosecution under the NDPS Act. Bail is difficult. The sentencing is intense. And ultimately, just kindly see the way how it is done. In fact, I have actually not taken your lordship through the evidence. It's shocking the way how it has happened. Absolutely shocking. An officer who comes and says he is not connected with Gurdev Singh, then comes later on and says he is connected and this is the evidence. I just want to just have that one line which he says earlier and one line which he says later. Because ultimately, my lord, divorced from facts, your lordship cannot look at it like this. Just kindly have that one line of that officer I want to read and the same officer's evidence later. Kindly have page 85, his first evidence. And he's a police officer. According to me, my lord, so far as such police officers are concerned, something very serious needs to be done with them. Correct? Correct. Kindly have page 86, that one line. And that one line is not a flash in the pan because I'm going to then take your lordship to 85. In what context that comes?
We have page 85 now.
Kindly come to page 86 first. Second line from the top.
Just 1 second. Huh?
This gentleman, my lord, his evidence starts at page 170, starts at page 78. He is Inspector Jaswant Singh, PW5. The second line from the top.
Yes, however,
I have no knowledge regarding association of Gurdev Singh, son of Sppech Singh, with Sukhpal Singh. He clearly says, I have no knowledge of any of his association. This question is not a flash in the pan. Now come back to 85. This is in the context he was being cross-examined that you are doing it maliciously to fix Sukhpal Singh because he's a political rival. Just kindly have in the middle of the page. However, it is correct that during March 15, your lordship got that middle of the page. However, it is correct that during March 15, Shri Sukhbir Singh Badal, Deputy CM of Punjab, was local MLA of Jalalabad. It is wrong that Gurdev Singh was very close associate of Sukhpal Singh Kheda. He says it is wrong that he was an associate of Sukhpal Singh Kheda. It is wrong that Gurdev Singh, son of so-and-so, was very close associate of Sukhpal Singh Kheda, ex-MLA of Congress Party, was senior Congress leader. Therefore, at the instance of political leader, Gurdev Singh was implicated in the false case. In this sit, it was constituted today. I do not remember for what purpose. It is correct that during the period, Sukhpal Singh Kheda was MLA and prominent Congress leader. It is correct that Sukhpal Singh filed a report, etc. Now your lordship may come at page 112, his examination later. What he says at 112? This is his examination later. Either he is lying then or now. Both can't stand together. Kindly have this. Now, this is the same officer, Jaswant Singh Malot, on his recall. Stated that during investigation, it came to my notice during interrogation of Gurdev Singh that he was allowed by Manjeet Singh, son of Bhutta Singh, to indulge in smuggling. It also came to my notice. Gurdev Singh was very confident that he will be saved by Sukhpal Singh Kheda because of his relations with Sukhpal Singh Kheda. Gurdev Singh told he was appointed chairman by Sukhpal Singh Kheda. It came to my investigation that Gurdev Singh was having family relation with Sukhpal Singh Kheda. He used to campaign in his election, objected to being not admissible. I have mentioned this case in the case diary Zimini dated 8 March 15. And that statement he made earlier was much later in 16. And what is this case diary? Please turn over the next page. The case diary, this is his cross. The case diary in this case has been prepared on plain paper. We are not in possession of any numbered printed format supplied by the government. Generally, we prepare a case diary on white paper. So some scraps of paper he has got, which is his investigation of 2015. And the whole purpose of this is to fix me. He has not stated any other thing. And when he is recalled, reason is that call records have to be connected with the original accused. There's not a word here.
That's why he rightly says not plain paper, plan paper. Read.
Plan, of course. That may be my...
You are not proper.
That may be divine correction, my lord, in my paper book. He may have said plain, but yes, he says plan. So, my lord, this is how, and my lord, it's very distressing that after that date of the 311 order, all that this man has been doing, Sukhpal Kheda, is contesting this litigation, and today, making this the base case, there is a PMLA investigation pending against him, in which he had to spend 3 months? 3 months in jail before he was bailed out. This is the base case. Because they have now alleged that this contraband money he tried to launder, etc. And he spent 3 months in jail. If I read the other person's evidence, it is worse. It's the same. He also initially says that Sukhpal Kheda is no way connected. Then he comes in a 2-page evidence. All that he does is connect me with Gurdev Singh. And the High Court says the quality of this will be seen when the cross-examination happens in the trial. That's how the High Court has rejected my submission. And now your Lordship may see what Hardeep Singh says regarding the kind of evidence which is required before you can actually connect an accused and call him under 319. I will read this in a little detail, the relevant part, because then ultimately I'm going to say that this is correctly decided and there is no question of your Lordship having any fresh look or clarification regarding this. Is going to be my submission.
Yes, we have.
Yes.
Please proceed.
This reference before the Lordship. This reference before us arises out of a variety of views having been expressed by this court. This is also 5 honorable judges. Hardeep Singh is 5 honorable judges. This reference before us arises out of a variety of views having been expressed by this court and several high courts of the country. The powers of the courts under the criminal justice system to arraign any person as an accused during the course of inquiry or trial, except as contemplated under 319 of the Code of Criminal Procedure. The initial reference was made by a 2-judge bench by order dated 7th November 2008 in the leading case of Hardeep Singh, where noticing the conflict between the judgments in Rakesh versus State of Haryana and a 2-judge bench decision in Mohammad Shafi, a doubt was expressed about the correctness of the view in Mohammad Shafi. The doubts as categorized in paras 75 and 78 of the reference order led to framing of 2 questions by the bench, which are reproduced hereunder. When the power under subsection 1 of section 3 code of addition of the exercised by it, whether application under 319 is not maintainable unless the cross-examination of the witness is complete. What is the test and what are the guidelines of exercising power under subsection 1 of section 319 of the code? Whether such power can be exercised only if the court is satisfied that accused summoned in all likelihood would be convicted. The reference was desired to be resolved by a 3-judge bench, whereafter the same came up for consideration, and by order dated 8th December 2011, the court opined that in view of the reference made in Dharampal versus State of Haryana, the issues involved being identical, the same should be resolved by a constitution bench consisting of at least 5 judges. The bench felt that since a 3-judge bench had already referred the matter of Dharampal to a constitution bench, then in that event it would be appropriate that such overlapping issues should be resolved by a bench of similar strength. Reference made in Dharampal came to in relation to power of court of session to invoke 319 at the stage of committal of the case to a court of session. Reference was answered by the constitution bench in Dharampal versus State of Haryana. It's the same at page 340. Wherein it was held that a court of session can, with the aid of 193 CRPC, proceed to array any other person and summon him for being tried, even if the provision of 319 would not be pressed into service at the stage of committal. Thus, after the reference was made by a 3-judge bench in the present case, papers, as so far as the court of session is concerned, to invoke 319 at the stage of committal, stood answered finally in the aforesaid background. On a consideration of the submissions raised, and in view of what has been noted above, the following questions are to be answered by this bench. First, what is the stage at which power under 319 can be exercised? Whether the word evidence used in 3191 could only mean evidence tested by cross-examination, or the court can exercise the power under the said provision, even on the basis of statement made in examination in chief of the witness concerned. Whether the word evidence used in 3191 has been used in a comprehensive sense and includes the evidence collected during investigation, or the word evidence is limited to evidence recorded during trial. What is the nature of satisfaction required to invoke the power under 319 CRPC to arraign an accused? Whether the power under 3191 CRPC can be exercised only if the court is satisfied that the accused summoned will in all likelihood be convicted. Does the power under 319 CRPC extend to persons not named in the FIR or named in the FIR but not charged or who have been discharged?
We are concerned with only 6.11.
Yes.
That's all. Only
Yes.
one. What stage? What is the stage at which?
Correct.
That is
But in view of the other 2 questions, your lordship would also have a overview of what the judgment holds. Because according to me, the judgment fully and comprehensively interprets 319. What is the nature of evidence required? At what stage it can be done? Whether it is evidence tested by cross-examination, whether it is pre-trial, everything is considered in Hardeep Singh. Hardeep Singh is rendered in 2014. It has been consistently followed by your lordships in a series of judgments. I will cite 2 or 3 of them before your lordships. It has been followed by the high courts consistently. And therefore, it is my submission before your lordships that this is absolutely correctly decided. And so far as my case is concerned, my case is definitely post-judgment, both on conviction and sentence. My case is one after conviction and sentence. And therefore, according to me, in the facts of this case, this Hardeep Singh need not be touched at all. I am completely and fully covered by Hardeep Singh. And apart from that, it is going to be my submission. I am covered by the very plain reading of the provision of 319. Trial. It says only during trial. The moment trial is over, that power cannot.
Mr. Patwalia, we will have to answer the reference.
Correct. The lordship would. And if I can just read those 3 questions again before I start, so that your lordship is, according to me, the framing or reframing is not material according to me. But in any case, just kindly see what the court says. Kindly see that relevant part of the reference order. It is here. No, I have got. So, page 13 of the reference is para 23 is the contention that, and then the questions are, later I can take your lordship straight to the questions actually. At page 15. The three questions. Whether the trial court, your lordship has got the reference order, that's the order dated 10th May 2009. 27 at page 15, the last one. In fact, if better if your lordship sees 23 also, because the mind of the honorable judges is, what is working in the mind is at para 23. It is contended, para 23, it is contended that the question of law herein is unique to the present case. Earlier judgment of Hardeep Singh did not have an opportunity to cast any light about the validity of a summoning order pronounced after the passing of the judgment. I pause here. Lord, this is completely answered in Hardeep Singh. I beg to differ with what is recorded here. And I will show to your lordship just now. After passing of judgment, Hardeep Singh says, no, the stage is over. So this is one. Then two, they further argue that Hardeep Singh treats 319 in an isolated manner without taking into consideration the spirit and mandate. I will just read it, my lord. Not only the code, the constitutional provision, the ethos of criminal jurisprudence, everything is considered by Hardeep Singh. It's a very detailed, considered judgment according to him. Then, my lord, this is one. To strengthen the aforesaid submission, the state further contended that 465 was introduced to provide for a balanced mechanism under the criminal justice system to stop the court from getting into hyper technicalities and committing violation. The court in Hardeep Singh has not considered the above principle or issues which could arise before the trial court while dealing with application under 319. The state therefore submitted that 319 should be not treated as an isolated island and instead given a pragmatic approach. The needs to be determined whether trial is set to be fully concluded, even if the bifurcated trial in respect of absconding accused is still pending consideration. That's not the fact situation in my case. If any trial of the absconding accused was pending, it would have been a different issue altogether. But then I could have been summoned in that trial. I could not be summoned in a trial which is already concluded, because it has all kinds of very serious problems. There is then a charge sheet will have to be called for. Then what happens to the evidence? Now, if I am again now to be tried in that same 2015 case that is pending in appeal before the High Court.
No, there you need not make something out of that. A separate number can be assigned. That is not an issue. Like absconding accused. That may not be a big issue.
So far as absconding accused is
no, separate number can be. We will direct him to give a separate number.
So far as absconding accused is concerned,
that's not a big issue.
No. So far as absconding accused is concerned, 299 places them in a totally different position. So far as absconding accused is concerned, 299 says there is no bar to continue trial. Even he can be charged.
No, bar, it's a fresh trial actually.
No. If he's not charged,
the evidence let in the previous case cannot be relied on straight away.
Not at all. It's a completely fresh.
It's a fresh case actually.
Correct. So will be the situation. So therefore, my lord, the position of an absconding accused is that he can under 299 be tried even in his absence. 299 says you can charge sheet him. So, and the evidence can be collected. He would be confronted with it as and when he is arrested, unless the person has died or those 2-3 exceptions are there. So my lord, then para 27, the three questions. Whether the trial court has the power under 319 for summoning additional accused when trial in respect of other co-accused has ended and judgment of conviction rendered on the same date before pronouncing the summoning order. Now, my lord, this is answered in Hardeep according to me completely. Whether the trial court has power under section 319 of the CRPC for summoning additional accused when trial in respect of other absconding accused is ongoing pending, having been bifurcated from the main trial. This is a completely different fact situation. It does not exist in my case at all. Now, and the answer to this question would depend on the facts under which this question is arising. If a trial is actually bifurcated and for some accused you pass judgment, then that trial is still pending for the other accused. And then, of course, 319 can be there. But that's a fact situation which doesn't exist here. And what are the guidelines for the court to follow while exercising power under 319? Those are adequately given in Hardeep Manoj. With this background now, kindly have Manoj para 8 onwards. How the court...
Mr. Patwalia, before that, let us read carefully 319 subsection 1 once again, right?
Yes, Manoj. Yes, yes.
319, once again we'll read carefully.
Yes.
Let us read 319.
Yes.
Please read, then we will go to Hardeep Singh.
Yes.
Yes. Where? Read in.
Where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person could be tried together with the accused.
So we will stop for a minute. Therefore, in the course of inquiry or trial, if something comes against a certain person for a, now at what stage can it be done? Next sentence you read. At what stage? The court may proceed against such, so the stage is not mentioned. At what stage the section doesn't say.
The stage is in the opening lines. In the course of any inquiry or trial.
That is in the course of the inquiry or trial and offence, it appears from the evidence that may...
It will have to be read for the entire sentence.
No, it is.
Where I understand what the way your lordship is reading it is bifurcating it. That evidence can be earlier and order can be later. Not. I don't. I would respectfully submit that the course of inquiry or trial it will have to be read with the entire provision.
Because it has to be tried together.
Correct. Correct. Correct.
Such person could be tried together with the accused.
Correct.
Oh, yes, yes.
The court may proceed. Now, in a judgment, your lordship said that this second part is directory. I don't agree with that judgment, Lord. In my respectful submission, that is also a matter for your lordships to see. Because then, that is that Shrikant. In Shrikant, the order had been passed during the when the trial was pending. So now kindly have 319.
So the language applied is such person could be tried together.
Correct.
Therefore, once the judgment is pronounced, how can you try together?
Correct. Absolutely. But absolutely. So, but then also read 3194.
Well, 3194 is de novo trial. 3194 is the procedure.
I am reading it.
Let us
I'm reading it. You will have your turn to read it.
Shrikant has clarified it.
Where the court proceeds?
Where the court proceeds against any person under subsection 1, then the proceeding in respect of such person shall be commenced afresh and witnesses reheard. Subject to the provisions of clause A, the case may proceed as if such person has been an accused when the court took cognizance of the offence upon which the inquiry or trial was commenced. Now kindly read 4B. If that trial is concluded and Shrikant is right in what it says, that it is directory, how are we going to reconcile this 4B with the first part?
Shashikant.
Sorry, Shashikant, sorry. So how are we going to reconcile clause B? It's not, we are now before 5 honorable judges. And I feel that it is directory is not a correct view. It's not, because then you are completely doing, rendering OTOs. The opening part of 3191, it has to be the same trial.
But then how do you reconcile 4A, subsection 4A? The proceedings in respect of such person shall be commenced
afresh and because all witnesses.
How do you reconcile this?
So all witnesses who have been examined in his absence before he is arraigned under 319 will have to be reheard, because naturally they will have to be recalled so that he can cross. Their chief may remain the same, but his lawyer will be entitled to cross them. So therefore, for cross-examination, they will have to be recalled. And the case, however it is clarified in B.
Proceedings in respect of such person shall be commenced afresh.
Correct. And witness is reheard.
So how do you say that it's only for the purpose of cross?
No, for all, your lordship is right. It will be as if fresh. But then read B. It's a scheme. Correct. Now read B also. subject to the provisions of clause A, the case may proceed as if such a person has been an accused when the court took cognizance of the offence upon which the inquiry or trial was commenced. Now, this necessarily presupposes a live inquiry or trial. It does not include an inquiry or trial which has already been concluded. That interpretation is very, it does not promote the cause of justice. Now, one trial is concluded. Let us take this case. Those witnesses, that is pending in the first appeal. In the same session case, I will be retried. Same witness will come. What if he gives a different evidence which is supporting the accused? How is those accused going to then? It will create a situation which is anomalous.
Actually, he becomes an accused
It will cause
retrospectively from the date of
absolutely
taken cognizance.
But my point is, my lord, that B therefore provides inbuilt a live inquiry or trial. And this court saying this is only directory and not mandatory is not correct. Now, just read 319, the opening part, where in the it actually doesn't directly arise here, but this is my respectful submission. Where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not accused has committed any offence for which such person could be tried together with the accused. The court may proceed against such person. So it is only if that person could be tried together with the accused that the court has to proceed against him.
Because the evidence must be recorded in the presence of the
One question to you. It may be difficult to answer, perhaps. Supposing a 319 application is filed in that accused case, what happens? Supposing.
On the basis of,
in every case there won't be a absconding accused, but in this case particularly,
if it is filed,
what would have happened?
If it, on the basis of the evidence there, I could have been summoned. If the court felt I had committed the offence.
So there
There
the
is-
trial is fine.
I cannot run away from that. That's the law. Then I will have to get that order tested that the evidence is not good enough because Hardeep Singh comments on that. But this argument is not available to me.
No.
Because that is a pending trial. And I can be summoned there. There is no doubt about it.
No, why?
Trial, he comments only if he is arrested. And he's,
Now, inquiry.
No, they have now filed a charge sheet.
No.
they have filed a-
Is he absconding or has he arrested?
he's still absconding?
He's facing trial. He's arrested and facing trial.
This contention of saying that the application cannot be filed after the trial would not have been available there.
Correct.
But still the validity of the application and the summoning order could have been essayed.
Because Hardeep says 319 is not an ordinary provision.
Correct.
If you are almost sure he's going to be convicted on the basis of what is before you, then call. Otherwise, don't call. That's the quality of evidence which Hardeep says.
Hardeep doesn't say in unequivocal words that once the judgment is delivered, the application cannot be granted. So if you see the answer at page 141,
Correct.
they only say that it can be considered at the stage of trial.
Correct.
Para 117.2.
No, that is said earlier, Lord. Those paras are earlier. I'll show your lordship. And I'll read that what your lordship is saying, Lord. Then show your lordship the relevant part. Your lordship is
Page 141,
141. Yes.
paragraph 117.2.
Three one nine. By section 319. Material coming before the court in course of such inquiry can be used for corroboration of the evidence recorded in the court after the trial commences for exercise of power under 319 and also add an accused whose name has been shown under 2. In view of the word, the evidence has to be broadly understood. Lord, this is regarding the evidence which they are answering.
No.
Both questions.
Yes,
To answer one question, 1 and 3, they answer it
correct.
together.
Correct. At para 38, but conclusion is para 47. This is the para 47, the top of it. But it starts from para 38. I'll read it. But anyway, 47, if your lordship will see. 40 also. From 38 onwards, I will have to read a lot, but I'm just reading this one line and then I'll go back to it. Since after the filing of the charge sheet, the court reaches the stage of inquiry, and as soon as the court frames the charges, the trial commences. Therefore, the power under 3191 can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during sections 207, 208 committal. This is the crucial part. So, and it's this is the discussion leads to it.
But Mr. Patwalia,
Yes.
now here, luckily or unluckily, one of them absconded and there is a separate trial. Now, even according to, they could have filed this 319 application in that. And in a case where there is no, there are no absconding witnesses, then they will lose the right forever.
Correct. They will not, because that's the stage. That's
So you must see that somebody is absconding.
no, not that. Not his absconding.
No.
The state-
We are telling you a peculiar situation. How to wriggle out of this?
No, not
Question, sir.
Huh?
Second question is about absconding. First question is without absconding.
Not actually.
Both questions are referred.
No, Hardeep Singh case, there is no absconding business.
No.
There is no absconding.
Actually, not 319 application is not even necessary. The power is conferred on the court on the principle that a guilty may escape, innocent may, but no person who has committed the crime should be allowed to get away. Now, this power is on the court. Now, here the state is nudging the court But just see 319 doesn't need an application.
No, they are not nudging the court, they are assisting the court. Put it in a.
So, yes.
Huh?
Their power is to charge me under 173. My learned friend is right. Their power after investigation, if they find something against me, is to charge me under 173. And they can file a charge sheet, a supplementary charge sheet, another charge sheet. Here they have come under 319. I mean, they could have, I was use the power under 173 if available. But here the 319 is actually not a power for an application to be filed. 319 is actually a power which is with the court. If your lordship may kindly now read it with this background with me. Where in the course of any inquiry or trial of an offence, it appears from the evidence that any person not being accused has committed any offence for which person could be tried together with the accused, the court may proceed against such person. So therefore, the court will only be able to produce if there is some live trial pending before it. So necessarily it has to be after the charge sheet is filed, when the inquiry commences, and before the trial is concluded. That's the only time when the court can proceed.
That's why the word course is used.
Correct.
Course.
Once your lordship is interpreting it,
The course.
correct. Hardeep Singh, Lord, according to me, takes into account everything and takes into account all.
Hardeep Singh, it does not clearly hold so, because even if you again turn to para 57.
Para 47.
57.
57. Thus, the application of the provision under section 319 at the stage of inquiry is to be understood in its correct perspective. Power under 319 can be exercised only on the basis of evidence adduced before the court during trial. So far as application during the course of inquiry is concerned, it remains limited to, as referred herein above, adding a person as an accused whose name has been mentioned in column 2 of the charge sheet, or any other person who might be an accomplice. Because there the court says during inquiry, court doesn't have any independent evidence. So only if a person is an accomplice or under column 2, court can shift him. But may I just read it from the stage where they start considering it? Lordship may just have. I'm just going to be.
All right, you read it.
I'm just going to be rather quick where it's not needed, but some paras I will have to read.
All right, take us through the.
Yes. So, Lord, the questions I had read, I don't need to read again. At para 6, I had read it.
Yeah.
Now, 7 is in this reference. What we are primarily concerned with is the stage at which such powers can be invoked. Now, that's one. In this reference, what we are primarily concerned with is the stage at which such powers can be invoked. And secondly, the material on the basis of whereof invoking powers can be justified. Second is not at large before your lordships. To add as a corollary to the same, third is the manner in which such power has to be exercised, also has to be considered. Then, my lord, articles 20-21 are considered in para 8. Para 9, my lord, I'll read the opening words. The presumption of innocence is the general law of the land, as every man is presumed to be innocent unless proven guilty. Alternatively, certain statutory presumptions in relation to certain classes of offences have been raised against the accused, whereby the accused presumption of guilt prevails till the accused discharges his burden, etc. My lord. Then, para 10, section 351 is referred to. Then, how cognizance is taken, that is considered, my lord. Then, on the next page, 114, 319 is mentioned. Then, my lord, para 12, I want to read. Section 319 brings out the doctrine of judex daemonor cum nosis absolvitur. Judge is condemned when guilty is acquitted. And this doctrine must be used as a beacon light while explaining the ambit and spirit underlying the enactment of 319. It is the duty of the court to do justice by punishing the real culprit, where the investigating agency for any reason does not array one of the real culprits as an accused. The court is not powerless in calling the said accused to face trial. The question remains, under what circumstances and at what stage should the court exercise its power as contemplated under 319? So it's a power of the court to do it. Then, my lord, the submissions are wide. Para 15 again. It would be necessary to put on record that the power conferred under 319 is only on the court This has to be understood in the context that Section 319 empowers the court to proceed against such person. The court, the word court in our hierarchy of criminal courts has been defined under Section 6 CPC, which includes court of session, judicial magistrate, metropolitan magistrate, etc. Then, my lord, definitions are given. I can leave that, my lord. Then, para 16. It is at this stage that the comparison of the words used under 319 have to be understood distinctly from the words used under 2G, defining an inquiry other than trial by a magistrate or a court. Hence, the legislature has used two words, namely the magistrate or court, whereas under section 319, as indicated above, only word court has been recited. This has been done by the legislature to emphasize that the power under 319 is exercisable only by the court and not by any officer not acting as a court. Thus, the magistrate is not functioning or exercising powers as a court, can make an inquiry in a particular proceeding other than a trial, but the material so collected would not be by a court during the course of inquiry or trial. The conclusion, therefore, in short, is that in order to invoke the power under 319 CRPC, it is only a court of session or a court of magistrate performing the duties as a court under the CRPC can utilize the material before it for the purpose of that section. This last part is important because after trial is over and judgment is pronounced, it ceases to be a court for the purpose of CRPC. It becomes functus officio. So therefore, my lord, that's the point. 17. Section 319 CRPC allows the court to proceed against any person who is not an accused in the case before it. Thus, the person against whom summons are issued in exercise of such power has to necessarily not be an accused already facing trial. He can either be a person under column 2 of the charge sheet under 173 or a person whose names have been disclosed in any material before the court that is to be considered for the purpose of trying the offense but not investigation. He has to be a person whose complicity may be indicated and connected with the commission of the offense. The legislature cannot be presumed to have imagined all the circumstances, and therefore it is the duty of the court to give full effect to the words used by the legislature so as to encompass any situation which the court may have to tackle while proceeding to try an offense, not allow a person who deserves to be tried to get scot-free by being not arraigned in the trial in spite of the possibility of his complicity, which can be gathered from the documents presented by the prosecution. The court is the sole repository of justice. Duty is cast upon it to uphold the rule of law. Therefore, it will be inappropriate to deny the existence of such power with the courts in our criminal justice system, where it is not uncommon that the real accused at time get away by manipulating the investigation and or prosecuting agency. The desire to avoid trial is so strong that an accused makes efforts at time to get himself absolved, even at the stage of investigation or inquiry, even though he may be connected with the commission of the offense. Then coming to the stage at which the power can be exercised, then, my lord, the earlier conflicting judgments are mentioned. That and then para 21, Dharampal is explained. I'll read that, my lord. At the outset, we may explain the issue that was being considered by this court in Dharampal was the exercise of such power at the stage of committal of a case. Court held that even if 319 could not be invoked at that stage, Section 193 could be invoked for the said purpose. We are not delving into the issue, which has been answered by a 5-judge bench of this court. Then, Lord, I can leave the rest of it here. Then, Lord, kindly come to para 25, which is important. What is the question being answered here is, what is the stage, the first question, at which power under 319 CRPC can be exercised? The stage of inquiry and trial upon cognizance being taken of an offense has been considered by a large number of decisions of this court that it may be useful to extract the same hereunder for proper appreciation of the stage of invoking the powers under 319 to understand the meaning that can be attributed to the words inquiry and trial as used under the section. In Raghubans Dubey, this court held once cognizance has been taken by the magistrate, he takes cognizance of an offense and not the offender. Once he takes cognizance of his offense, it is his duty to find out who the offenders really are And when he comes to the conclusion that apart from the person set up by the police, others are involved in, it is his duty to proceed against those persons. Summoning of additional accused is part of the proceeding. Now, 27 is important. The stage of inquiry commences insofar as the court is concerned with the filing of the charge sheet and the consideration of material collected by the prosecutor that is mentioned in the charge sheet for the purpose of trying the accused. This has to be understood in terms of Section 2G CRPC, which defines an inquiry as follows. Inquiry means every inquiry other than a trial conducted under this code by a magistrate or court. Then, my lord, I can leave para 27, my lord, para 29. Para 28, I can leave, para 29. This trial is distinct from an inquiry and must necessarily succeed it. The purpose of trial is to fasten the responsibility upon a person on the basis of facts presented and evidence led in this behalf. In Molly versus State of Kerala, this court observed that though trial is not defined in the code, it is clearly distinguishable from inquiry. Inquiry must always be a forerunner to the trial. Then, note 30 also, the word tried and trial appear to have no fixed or universal meaning. No doubt in quite a number of sections in the code to which our attention has been drawn, the words tried and trial have been used in the sense of reference to a stage after inquiry. That meaning attaches to the words in those sections, having regard to the context in which they are used. There is no reason why these words are used in another context in the code. They should necessarily be limited in their connotation and significance. They are words which must be considered with regard to the particular context in which they are used and with regard to the scheme and purpose of the provision. Then, my lord, I can leave those other judgments which are referred to, and your lordship can come to para 38 straight away. Para 38. In view of the above, the law can be summarized to the effect that as trial means determination of issues adjudging the guilt or innocence of a person has to be aware of what is the case against him, and it is only at the stage of framing charges the court informs him of the same. The trial commences only on charges being framed. Thus, we do not approve the view taken by the courts that in a criminal case, trial commences on cognizance being taken. So, inquiry is when charge sheet is filed, and when charge is framed, that inquiry, as per Hardeep Singh, gets converted into trial. That's my understanding of what is laid down in Hardeep Singh so far. Then we proceed further. 39. Section 2G CRPC and the case laws referred to above, therefore, clearly envisage inquiry before the commencement of trial and is an act conducted under CRPC by the magistrate or the court. The word inquiry is therefore not any inquiry relating to investigation of the case by the investigating agency, but is an inquiry after the case is brought to the notice of the court on filing of the charge sheet. The court can thereafter proceed to make inquiries, and it is for this reason that an inquiry has been given to mean something other than the actual trial. Even the word force occurring in section 319 clearly indicates that the power can be Para 40. Even the word occurring in section 319 clearly indicates that the power can be exercised only during the period when the inquiry has been commenced and is going on, or the trial which has commenced and is going on. It covers the entire wide range of process of pre-trial and trial. The word course, therefore, allows the court to invoke this power or person from the initial stage of inquiry up to the stage of conclusion of the trial. The court does not become functus officio, even if cognizance is taken, so far as it is looking into the material for any other person who is not an accused. Word course ordinarily conveys a meaning of a continuous process from one point to the next in time and conveys the idea of a period of time and duration and not a fixed point of time. In somewhat similar manner, it has been attributed to the word course, the meaning of being in gradual continuous flow, advanced by the journey or passage from one place to another with reference to period of time. To say that the power under 319 can be trial would be reducing the impact of the word inquiry by the court. It is settled principle of law. The interpretation which leads to conclusion that the word used by the legislature is redundant would be avoided, as the presumption is that the legislature has deliberately and consciously used the word for carrying out the purpose of the act. The legal maxim, virgis legal non est rescindum, which means from the words of law there must be no departure, has to be kept in mind. Then, my lord, then 44 is important. No word in a statute has to be considered as a statute. No word can be rendered ineffective or purposeless. Courts are required to carry out the legislative. Full effect is given. I can leave that. Then para 45 also is interpretation. Then 46 is the conclusion that by no means it can be CRTC cannot be pressed into service during the course of inquiry. The word inquiry in the said provision. Then, since after the filing of the charge sheet, the court reaches the stage of inquiry, and as soon as the charge trial commences, therefore the power the exercise of sections 7, etc. It is only trial stage intended to put the process in motion. This stage cannot be said to be a judicial step in the true sense, but it will be as an application rather than judicial. This pre-trial stage is required to perform the act in the nature of administrative rather than judicial procedure. That's equaling compliance matters if it is exclusively prior to the session. For us to magistrate stage of time is term has to be any action needs to be added on face value. It may be pertinent to refer to Raj Kishore Prasad there or avoid delayed next. Then I can
basically rely on the first sentence of paragraph 40.
yes, 50 inquiry or trial again.
The question there appears to be as to whether the powers should be exercised only at the stage of a trial or even prior to it.
Correct. Correct.
The court held that even prior to that also it is permissible.
Because trial
Except 207, 208 and commitment.
and trial actually has a well-defined meaning, because once you pronounce judgment, trial is then completed. Trial doesn't remain pending after that. So therefore, my lord, it says till pronouncement of judgment. Now kindly see 53, 54 also quickly, my lord. It is thus aptly clear that until and unless the case reaches the stage of inquiry or trial, the power under 319 cannot be exercised. In fact, this proposition does not seem to have been disturbed by Dharampal. Then Dharampal is discussed or not. In our opinion, the stage of inquiry does not contemplate any evidence, etc. in the strict sense, nor could the legislator have contemplated this as much as the stage of evidence has not arrived. Material, then my lord, I can leave all this, my lord. Then 55 is the conclusion. And 57, if your lordship will have. Actually, 56 and 57, my lord. There is 56 and 57 only. There is yet another set of provisions which form part of inquiry relevant for the purpose under 319, provision of section 200, 201, 202 CRPC, applicable in the case of complaint cases. As has been discussed, evidence means evidence produced before the court. Complaint case is a distinct category of criminal trial where some sort of evidence, I can leave this one actually, 57. Thus, the application of provisions of 319 at the stage of inquiry is to be understood in its correct perspective. Power under 319 can be exercised only on the basis of evidence adduced before the court during a trial. So far as application during the course of inquiry is concerned, it remains limited to referred herein above, adding a person as accused, etc. Then, my lord, what is the nature of evidence, etc.? I need not go into it. But para 78, it is answered by saying that it is only evidence during trial. If your lordship will have para 78 on the second question. '78, it is therefore clear that the word evidence in 319 means only such evidence as is made before the court in relation to statements and as produced before the court in relation to documents. It is only such evidence that can be taken into account by the magistrate or the court to decide whether power under 319 is to be exercised, not on the basis of material collected during investigation. So it's only what has come before the court that can be looked into. Then, then means evidence examination in chief or cross is the next issue from 86 that your lordships have said that it can be at the stage of examination.
Examination in chief also.
Para 92 is the answer there.
Not necessary to wait for cross-examination.
Correct. Para 92 is the answer. Thus, in view of the above, we hold power under 319 can be exercised at the stage of completion of examination in chief, and the court does not need to wait till the evidence is tested on cross-examination.
It's basically one sentence in paragraph 47 on which you are arguing.
But the words of the statute also, trial, because that's
plain interpretation.
Now, just before I leave this judgment.
To come to that 47 conclusion in that first sentence para,
correct.
All this discussion was necessary perhaps.
Correct.
Inquiry, trial, etc., etc.
Correct. Now, just one before I leave it. Just kindly have para 95. Because what is the nature of... I'm just trying to show your lordship, it's not casually you don't add a person. What Hardeep Singh recognizes this. Just kindly have para 95.
Basically, the intention of the legislature is that if some accused manages at the investigation stage to get scot-free and the court gets some material, that such a person should not have been scot-free and he should be brought to the trial. The power can be exercised by the court.
Correct.
To do complete justice.
Correct. And what is the nature of material? Just kindly read para 95 with me. In fact, the last line, third line from the top at page 135, and then para 95 and the conclusion. The court held, third line from the top, your lordship has got the court held that for fulfillment of condition, it appears that a person had committed an offence, the court must satisfy itself about existence of an exceptional circumstance, enabling it to exercise an extraordinary jurisdiction. I'm only trying to impress upon your lordships, my lord. It's a life-changing situation for a person to be added as an accused. So, what is therefore necessary for the court is to arrive at a satisfaction that the evidence on behalf of the prosecution, if unrebutted, may lead to conviction of the person. Now, the next four lines also. At the time of taking cognizance, the court has to see whether a prima facie case is made out to proceed against the accused under 319 CPC. Though the test of prima facie case is the same, the degree of satisfaction required is much stricter than a two-judge bench is quoted. Just kindly a para 97. In Muhammad Shafi, this court held that it is evidence that is before the court exercises discretionary jurisdiction must arrive at a satisfaction that there exists a possibility that the accused so summoned in all likelihood would be convicted. And then, my lord, again, 98, 99, the same test, and the conclusion is in para 105, 106 on this point. Just kindly have those two paras. The entire discussion is such a high degree of evidence is required. It's not that you are just casually or on some any evidence you are just exercising that power. Now, just kindly have 105, 106. Power under 319 is discretionary and an extraordinary power. Para 105 I'm reading. Power under 319 is a discretionary and an extraordinary power. It is to be exercised sparingly and only in those cases where circumstances of the case so warrant. It is not to be exercised because the magistrate or the session judge is of the opinion that some other person may also be guilty of committing that offense. Only when strong and cogent evidence occurs against a person from the evidence led before the court that such power should be exercised and not in a casual and cavalier manner. Thus, we hold that even though only a prima facie case is to be established from the evidence led before the court, not necessarily tested on the anvil of cross-examination, it requires much stronger evidence than mere probability of his complicity. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing of the charge, but short of the satisfaction to the extent that evidence, if it goes unrebutted, would lead to conviction. In the absence of such satisfaction, the court should refrain from exercising power under 319. Section 319, for the purpose of providing, if it appears from the evidence that person is not being an accused has committed an offense, is clear from the word for which such person should be tried together with the accused. The words used are not for which such person should be convicted. There is therefore no scope for the court acting under 319 to form any opinion as to the guilt of the accused. So, my lord, this is the level of satisfaction, and then in the conclusion, it is again stated, my lord, at 117. But this is so far as Hardeep is concerned, my lord. In fact, the conclusions are on this point. The conclusion is 117.5. But on the earlier point, what is the stage? And that, as my Lord Justice Gawai had rightly pointed out, it's 117.1, 2, and 3. I can just quickly read those ones. 117.1. In Dharampal, the Constitution Bench has already held that after committal, cognizance of an offence can be taken against a person, not named as an accused, but against whom materials are available from the papers filed by the police after completion of the investigation. Such cognizance can be taken under 193. Session judge need not name under evidence. Then 117.2. 319 significantly uses two expressions that have to be taken note of: inquiry and trial. As trial commences after framing of charge, an inquiry can only be understood to be a pre-trial inquiry. Inquiries under section 200, 201, 2 and 398 are species of inquiry complaint contemplated. Material coming before the court can be used for corroboration, etc. Then, my lord, evidence. And then regarding evidence, they say that the degree of satisfaction has to be very high. This is 117.5. Go under section 3194B CRPC. The accused subsequently pleaded is to be treated as if he had been an accused when the court initially took cognizance of the offence. The degree of satisfaction that will be required for summoning a person under 319 would be the same as for framing a charge. The difference is the degree in the degree of satisfaction for summoning the original accused and subsequent accused on account of the fact that trial may have commenced against the original accused, and it is in the course of such trial that materials are disclosed against the newly summoned accused. Fresh summoning will result in delay of the trial, etc. So this is Hardeep Singh. Then not just also see Justice Sabarwal's judgment in Shikam. That is 2002, volume 5 SCC, page 738. Shikam. Though the reference order itself says that is a little different, but I just want to take your lordship through it. Part itself. Can a person summoned pursuant to an order passed by a court in exercise of power conferred by Section 319 of the Code of Criminal Procedure be tried for offence for which he is summoned after the conclusion of the trial wherein such an order of summoning was passed, is the question that falls for determination in this appeal. Such a question regarding interpretation of 319 has arisen for the first time. The answer would depend upon the interpretation of the words could be tried together with the accused in section 619 of the code. Question has come up for consideration under the following circumstances. On the statement of Shashikant Singh, a case under 302-334 and under section 27 of the Arms Act for murder of his brother was registered against 5 persons, including R1 and also one Chandrasekhar Singh. On completion of investigation, police submitted a charge sheet against Chandrasekhar, showing the other accused as absconders. So far as R1 is concerned, investigation was shown to be pending. Under Chandrasekhar Singh, against Chandrasekhar Singh, the Court of Session framed charge under 302 IPC and 27 of the Arms. By order dated 7th April 2001, the learned additional session judge held from the evidence of prosecution witness, it appears that respondent number 1 and 2 others have committed the offence for murder of Shivkant Singh. The warrant of arrest against these persons were directed to be issued so that they may be tried together with the accused Chandrasekhar Singh. This order was challenged by respondent number 1 in criminal revision filed in the High Court of Judicature at Patna. During the pendency of the aforesaid revision, the learned session judge concluded the trial against Chandrasekhar Singh and believing the ocular testimony, by judgment dated 16th July 2001, Chandrasekhar Singh was convicted for the offence under section 302 IPC and 27 of the Arms Act. In the other revision petition, it was contended on behalf of respondent number 1 that since the trial in respect of Chandrasekhar Singh had already been concluded and no session trial is pending before the trial court, section 319 could not be applicable as the said provision is applicable only when trial against another accused is pending, and in the absence of pendency of the trial, the court is not competent to proceed against respondent number 1. The High Court by the impugned judgment accepted the aforesaid contention and held that the order dated 7/4/2001 is without jurisdiction. The order dated 7/4 was quashed without notice to the petitioner on hearing the counsel for the state of Bihar. The other contentions was that investigation was kept pending, and on that score, the court had no power to summon the accused under 301, etc. Now, so therefore, Lord, that is how the order gets set aside. The trial against Chandrasekhar was pending on 7th April 2001 when the order under section 3191 of the code was passed by the Court of Session. Thus, the order when passed cannot be said to be without jurisdiction on the stated ground, since at that stage, the trial under Chandrasekhar Singh was pending and respondent number 1 summoned under 319 could be tried together with him. However, the trial against Chandrasekhar Singh concluded before respondent 1 could be brought before the session court. Therefore, the question is, can respondent number 1, after being summoned under 319 of the code, be tried in the absence of trial pending under Chandrasekhar Singh? In other words, the aspect to be determined is as to whether the order dated 7th April 2001 would be ineffective and inoperative as a result of conclusion of trial against Chandrasekhar Singh before respondent number 1 could be proceeded with for the offence for which warrants were issued against him pursuant to an order passed under 319. Then the section is quoted. Clearly, the proceedings against the person summoned under subsection 1 are required to be commenced afresh and the witnesses reheard. The entire proceedings have to commence from the beginning of the trial. All witnesses have to be examined afresh. Opportunity has to be granted to such person to cross-examine these witnesses. there has to be a de novo trial. The effect of conclusion of the trial against the accused who was being proceeded with when the order was passed under 319 for proceeding against the newly added person is to be examined in the light of subsection 4 of section 319, which stipulates a de novo trial in respect of the newly added person and certain well-settled principles of interpretation. When a statute is passed for the purpose of enabling something to be done and prescribes the way in which it is to be done, it may either an absolute enactment or a directory enactment. The difference being that an absolute enactment must be obeyed or fulfilled exactly, but it is sufficient if a directory enactment be obeyed or fulfilled substantially. No universal rule can be laid down as to when mandatory enactments shall be considered directory only, or obligatory with implied nullification for disobedience. It is the duty of the courts of justice to try to get to the real intention of the legislature by carefully attending to the whole scope of the statute construed. The intention of the provision here is that when in the course of any inquiry or trial of an offense, it appears to the court from the evidence that any person not being accused has committed any offense, the court may proceed against him for the offense for which he appears to have committed. At that stage, the court would consider that such a person could be tried together with the accused, who is already before the court facing trial. The safeguard provided in respect of such person is that the proceedings right from the beginning have mandatorily to be commenced afresh and witnesses reheard. In short, there has to be a de novo trial against him. The provision of de novo trial is mandatory. It vitally affects the rights of a person so brought before the court. It would not be sufficient to only tender the witnesses for cross-examination of such a person. They have
Witnesses should be reheard. Witnesses should be reheard. Then in which case, do the other accused have an opportunity to cross-examine these witnesses once again?
Therefore, that's the whole point. Therefore, it must happen when the trial is still live.
No,
Otherwise,
no, this
they will not. Obviously,
you
answer
agree.
is no.
No, you agree.
Answer to your lordship's query is no.
No, you agree that before the judgment is pronounced, this could have been done. If that is so, then whether the other accused get an opportunity to cross-examine once more, all that is a problem.
But my
Therefore, do the other witnesses get an opportunity to cross-examine once more?
yes, sure.
It's amended. Trial is to commence afresh, not only against him, against all.
Against all.
Yes, against all. Which means from the evidence recorded already, is no evidence against this man because it was recorded in his absence.
So the evidence recorded earlier is washed away.
No evidence.
No, against,
No, recorded in his absence.
no, against,
Even chief examination, cross-examination, everything is washed off because it is no evidence against him. A fresh evidence is to be recorded.
no, against him, fine. But against the others, do they get an opportunity to cross-examine?
There is joint trial. There is joint trial. Therefore, evidence is not there. Fresh evidence is to be taken both in chief as well as in cross. In which case, they will be entitled to cross-examine them. What for the evidence already recorded and cross-examined could be used is only for the purpose of the contradiction.
Cross and contradiction.
145,
By
145.
for that matter.
145.
It's the only thing.
I don't agree. I will make my submission. Then
All right, sir, all right. All
The
right.
issue is totally different.
Lord, let me finish reading it. I have one or two things to point out here. And therefore, my Lord, therefore, just see 319 opening part. That's 3191 is where the power is conferred. That power is conditional. And please read the whole of 3191. You cannot just say it is directory and wish it away, because that's the main provision. Where in the course of any inquiry or trial of an offense, it appears from the evidence that any person not being accused has committed any offense for which such person could be tried together with the accused. It goes hand in hand. When you find a person has committed an offense for which he can be tried along with the existing accused, then you can proceed against that person. So therefore, this Shashikant, which says this is directory, is completely doing violence to the provision of the section. This power 319 is the main provision. 3194 is procedural. What is the procedure to be followed now once you have called him before you? Because 2 and 3 say how you are to call him now before you. The main power to add him is conditional to the fact that he has to be tried with the others. And therefore, 2 and 3 says, once you have added him, how are you going to call him? And 4 says how you are going to try him. And this judgment, sometimes not hard cases make bad law. Now, this was a case where he was added in time. Then he goes to the High Court and says,
Your case is a soft case or hot case?
No, Patwalia will certainly.
soft but hard for me, my lord. So, otherwise,
Patwalia will say it is a hard case for the simple reason. In the main examination, he has, in the main cross-examination, he has said in your favor.
correct.
But after recalling,
He suddenly changes his mind. I mean, they should be prosecuted under 340, these people. But anyway, my lord, that stage also will come in life one day, my lord. Well, ultimately, it goes there. But now I'm just referring to this Shashika. I'll just read it and then just make a small critic, my lord, since your lordship can actually have a fresh look at it. And therefore, my lord, what is the rationale of the court? Well, this was a very hard case. This was a bad case. He's added in time. It's a case of murder. He files a revision and gets it lingering on, or somehow it remains pending. In the meantime, the trial concludes. Now the court is faced with the situation where you prima facie find he has killed a man. Are you going to just let him go like that? So that's the fact situation existing here. And that is what the court, in fact, set out to correct. Now, if I may read it, Lord.
Mr. Patwalia, what has, this judgment has been distinguished in Hardeep Singh. What is the position?
Lord,
This is subsequent. No, 2002.
No, this is earlier.
No, what happened? What has the?
The reference court order has distinguished it by saying.
No. What has the?
I'll just check.
Done with this, Shashikant.
Well, Hardeep has not been.
Hardeep Singh doesn't refer to it.
Not referred, is it?
Well, Hardeep Singh has not, but while referring, Millard, this court has referred to both the judgments and has said that judgment gives the law regarding the fact that 319 summoning is before the trial ends and when the proceedings are pending in the High Court. So the reference was only to the extent.
On facts, it is different.
Yes. So the court says yes.
There
it's
was
a right.
no stay order in the High Court, perhaps.
Yes, Millard, as far as Shashikant is concerned, Mr. Patwale, as far as Shashikant is concerned, Millard, 319 was allowed before the trial had concluded. So the Honorable Court said Shashikant lays the right law regarding the fact 319 allowed before the conclusion of trial. But in the present case, since the argument raised was that 319 has been allowed after the conclusion of trial, so this is different, that reference has been made. So reference is, because 319.1 is clear, 319.1 says who can be summoned. So it is could be summoned, 319.1.
Now I can.
We will hear you, sir. We will hear.
Yes.
So Lord, the reference order, in fact, distinguishes this. If the reference order is read, the reference order has distinguished it and said, this is a separate factual situation. But I am going a step further. because this says something which will cause, which may we
that is not a question which is referred, so we can't answer.
correct.
We can't answer the
Correct.
question in abstract.
So my lord, what the reference?
We'll have to only restrict our reference to what is referred to us.
Correct. That's right. But otherwise, my lord, I am bringing into your lordship's notice that so far as, just let me finish, because they will in any case read it. The learned solicitor wants to read it. So therefore, let me just take your lordship through it quickly, my lord. Before now, just kindly see para 7. So the effect of the conclusion of the trial, para 7. The effect of conclusion of the trial against the accused who was being proceeded with, when the order was passed under 3191 for proceeding against the newly added person, is to be examined in the light of subsection 4 of section 319, which stipulates that a de novo trial in respect of newly added person and certain well-settled principles of interpretation. When the statute is passed for the purpose of enabling something to be done and prescribes the way in which it is to be done, it may either be an absolute enactment or a directory enactment. The difference being that an absolute enactment must be obeyed or fulfilled exactly, but it is sufficient if a directory enactment is obeyed or fulfilled substantially. No universal rule can be laid down whether mandatorily enactments should be construed directly, only, or obligatory with an implied nullification for disobedience. It is the duty of the courts of justice to try to get at the real intention of the legislature by carefully attending to the whole scope of the statute. The intention of the provision here is that when in the course of any inquiry into or trial of an offence, it appears to the court from the evidence that any person not being accused has committed any offence, the court may proceed against him for the offence which he appears to have committed. At that stage, the court would consider that such a person could be tried together with the accused, who is already before the court facing the trial. The safeguard provided in respect of such person is that proceedings right from the beginning have mandatorily to be commenced afresh and witnesses reheard. In short, there has to be a de novo trial against him. The provision of de novo trial is mandatory. It vitally affects the right of a person so brought before the court. It would not be sufficient to only tender witnesses for cross-examination of such a person. They have to be examined afresh. Fresh examination in chief, and not only their presentation for the purpose of cross-examination, is the mandate of 3194. The words cannot be tried together with the accused appear to be directly. I would respectfully submit, my lord, perhaps your lordship would have to have a fresh look at this part of the order. The words could be tried together with the accused appear to be directly. Could be, cannot under these circumstances be held to be, must be. The provision cannot be interpreted to mean that since the trial in respect of a person who who was before the court has concluded, with the result that newly added person cannot be tried together with the accused who was before the court.
No, Mr. Patwani, actually, the commencement of the de novo trial, even by the wording of subsection 4, is only against such person.
Correct.
Therefore, such person is the person who is summoned under 319.
Correct.
So we don't think that you start the trial afresh de novo in respect of all accused. If it is against all accused, such person.
No, I bow before your lordship's observation. It is such person. It is such person, and that evidence which is tendered in the same trial in respect of such person can always be referred to at the time of arguments when you are finally arguing the matter for acquittal or conviction. But my respectful submission is that 319 is the main. Kindly now just quickly see 2 and 3 with me. 2, 3, 4 are all procedural. That once you have called him, now what are you going to do with him? How are you going to secure his presence, and how is the trial to proceed against him? Because he is already charged now. That part is over now. You have called him, so he is now going to face that charge. So just see 2. Where such person is not attending the court, he may be arrested or summoned as the circumstances of the case may require for the purpose of the aforesaid. Procedural. 3. Any person attending the court, though not under arrest or upon summon, may be detained by such court for the purpose of inquiry into or trial of the offence which he appears to be committed. 4. Where the person proceeds against the person under subsection 1, then it shall be afresh. So the substantive provision, this judgment says, is directory. That is the substantive provision under
In
319.
any case, that is not a question which has been
My lord, I am only, tomorrow they will argue that because Shashikant says fresh trial, so what is the problem? We will have a fresh trial for him. Why is he, my lord, so therefore I am only trying to avoid such a situation at that stage.
Tomorrow again.
Yes.
We'll meet tomorrow.
And the High Court judgment extensively goes on Shashikant. It says, it in fact does not follow Hardeep Singh saying, no, Shashikant is the right one. And therefore, initially on day one.
How does the High Court deal with para 47?
I'll show your lordship tomorrow. And in fact, on the very first day, when notice was issued only on this ground that a 5-judge bench has been ignored in favor of a 2-judge bench. So that's how we started this journey, my lord, before your lordships in 2017.
The lordship, may I mention IA number 172980, which we have preferred in this case.
Where it, in this case?
In this case.
Tomorrow you make a submission.
Permission to.
Tomorrow.
He can't be added just like that, my lord.
I only seek.
We have not allowed it.
Yes.
Only submissions.
We have also filed an impleadment application which is not.
You are on behalf of PMLA.
Yes.
President of India. My lord said we will hear you, therefore I.
We will not allow any applications, but if somebody wants to assist, we will hear you.
Assistance.
But very brief, it should be 5 minutes.
Less than 5.
Now, your ED has attached all the judgments.
My lord, the ED is
Only for the assist purpose.
that application tomorrow.
And I was told that I could assist, that was what I was told.
Only for this.
Great.